presently working as UDA cum accountant and posted at the Kalaigaon ICDS project in the district of Udalguri. The wife of the petitioner is also a government servant and is presently posted as a supervisor in the Jala ICDS project. Due to family reasons and more particularly the upbringing of their 9-year-old son, the wife of the petitioner is compelled to reside at Borpeta and wherefrom she is attending her official duties at Jala ICDS project. Since the petitioner is posted at Kalaigaon ICDS project under Udalguri district, he is required to travel more than 300 kilometers each time he wishes to stay with his family. According to Mr. Mazumdar, the separation of the petitioner from his wife and the child is not only causing immense mental agony to his client, but the travel distance is also causing hardship to him. So so submits the post of UDA cum accountant in Jala ICDS has recently fallen vacant. There is no scope. Therefore, there is a scope for the authorities to transfer and post the petitioner in the Jala ICDS project as UDA cum accountant. If the same is done, the petitioner would get an opportunity to live with his family and look after his son. As such, on 26/12, the petitioner submitted a representation before the respondent number 2, narrating the background of the case with the prayer to transfer into Jala. The grievance of the petitioner is that till today the representations have not been considered by the authority. Mr. Soenso, Learned Standing Counsel BTC, appearing for the respondent, submits that the representation dated Soenso submitted by the petitioner can be considered by the competent authority if not already done, if some time is granted by the court. If that be so, there is no justifiable reason for this court to keep the repetition pending. I therefore dispose of the repetition with the direction upon the respondents, more particularly the respondent number 2, to consider the representation dated so submitted by the petitioner sympathetically, and unless there is any legal hurdle coming in the way of his transfer to ICDS project, Jala, appropriate order may be passed in the matter, keeping in mind the factual circumstances of the case. Now, my lord, hereafter, the petitioner was transferred at page 50, lordship will find, to the Jala ICDS project on 1st of March 2023.
Yes.
The date would be little important, my lord. 1st of March 2023, I was transferred to the Jala ICDS project. Immediately thereafter, lordship will find at page 52, 10th of March, the petitioner is posted out from the Jala ICDS project and required to go to Bureaucratic ICDS project, keeping again putting him in the jeopardy of the travel distance, my lord. This occasion, when I approach this honorable court, lordship will find at page 54.
Yes.
This honorable court on the motion day had, my lord, at page 57. I'll read from page 56, my lord. The second paragraph from below, in pursuance thereto. Lordship will find, in pursuance thereto, it appears that an order was passed on 1/3/23, whereby the petition was transferred from the office of the CDP of Kalaigaon project to the office of the CDP of Jala project. However, after 9 days, that is on 10th of March, the said order dated 1/3/23 was modified, whereby instead of posting the petition to the office of the CDPO, the petitioner was posted to the CDP of Kalaigaon ICDS project. Petitioner is agreed with the order of 10/3. Learned counsel for the petitioner submitted that in terms with the order dated 1/2/23 passing WPC post 70 of 23, there was a specific direction passed by this court to keep the post of UDA accounted at Jala ICDS project vacant. And in spite of the post being vacant, which could be apparent that the petitioner was posted of the said post on 1/3/23, the respondent authorities have modified the said order dated 1/3/23 and posted the petitioner to the office of the CDPO project, Gureshwar ICDS project, Bhaskar.
So that was stayed.
My lord?
That order was stayed.
That order was stayed, and thereafter at page 58, they posted me back to Jala on 28th of March 2023. Now, my lord, when I was posted, when my wife and I was posted at Jala from 20th of March 2023, at page 62, an order dated 4th of December by which my wife again was posted out at serial number 182.
Page number?
Page 62, my lord, it starts. Page 62, my lord, a new transfer order.
No, what happened to...
My lord, we stayed together from 28th of March 2020. The other petition was closed, my lord.
Yes.
That order, lordship would find.
All right.
That was closed at page 60, my lord.
Then
page
comes...
62, my wife is again transferred out on the 4th of December in 9 months.
Where is her name?
Page 63, serial number 182.
182.
Lordship will find from Jala ICDS project to Khairabari.
Okay.
Separating us again. Now, this time, my lord, my wife approached this honorable court.
Yes.
And lordship will find lordship's order at page 65 onwards. Relevant portion, if lordship comes to is at page 68. Otherwise, from page 67 to page 66 and 7 is the restoration of the old part. Page 68, Lordship's consideration. On careful perusal of the pleadings on record, as well as the orders dated 16/7/21 passed in WPC number so-and-so, order dated so-and-so passed in WPC 470, and order dated 22/3/23 passed in WPC 160, passed by this court, it is seen that earlier the court considered the prayers of the petitioner as well as the husband of the petitioner for transfer to Jalo ICDS project, and consequent thereto the husband of the petitioner was placed at Jalo ICDS project. These orders were passed considering the fact that both husband and wife are working under the same department as UDA and supervisor, and considering that they have a child of 10 years, and on the request made that they should be allowed to be posted in the same district, this court had considered their prayers and passed certain orders on the basis of these orders. The department has also considered the prayer of the husband of the petitioner to post him at Jalo ICDS project. However, in view of the order dated 4/12/23, wherever the petition has been sought to be transferred out of Jalo to Khoidabari, this prima facie appears to be issued without taking into consideration the spirit of the orders dated 16/7/21 passed in so-and-so, dated 1/2/23 passed in so-and-so, and dated 22/3/23 passed in WPC so-and-so, passed by this court. Under these circumstances, considering that the representation is stated to be pending, this court is of the considered view that the representation which is filed on 15/12/23 and enclosed at page 10 of an extra 10 page 45 be disposed of by the Joint Director cum Chief Head of the Department, Women and Child Development Department, BTC Kokrajhar, by passing a speaking order considering the claim and prayers made by the petitioner. This representation be disposed of, and therefore a copy of the speaking order be served to the petitioner also. I made the representation at page 70. Lordship will find my wife was then transferred out to Bojali. Now, my wife has gone and joined at Bojali. She is traveling from home. All of a sudden, on
You were
at
you
page
were
70
you were posted at Boxa.
at Jalo,
Jala.
and my wife is now posted to Bojali.
Bojali.
Instead of fighting it out from Bojali also, my wife went and joined there. She was ready to travel. 24th of January 2024 at page 71, in the interest of public service, the petitioner of this CDPO Jalo is hereby transferred and posted in the office of the principal, Boroma. Again, I'm required to move another 200, around 200 kilometers from Jalo. Now, my wife might not having accepted her posting at Bojali. This honorable court earlier holding that we should be allowed at least to be together for some time, my lord. In 9 months, we are now again both posted up from the same station. Now, Lordship will find one of my statements at page 21, where, my lord, I have given some of the grounds. Lordship will find the last paragraph of page 21. Thirdly, the respondent number 2, while passing the impugned order, has miserably failed to consider the fact that the post of LDA cum typist and statistical assistant, both are, one is my wife, one is me, in the Jalo ICDL project are vacant, and therefore impugned transfer would be rendered a Jalo ICDL project without the offices. Even at the risk of keeping the one particular office without LDA typist and the statistical assistant, they are yet held bound to keep me and my wife separate despite my 3 or 4 orders from this honorable court, considering the fact that I have a minor child and we are required to travel along with him. At this stage, my lord, may I agree that the impugned transfer order of 24th January 2024, my lord, if it is kept in abeyance for some time, allowing them to place before this court, what is the urgency where me and my wife are to be separated despite so many orders of this honorable court within a period of 10 months?
Yes, who's for the respondent?
Lordship, I have to take instruction because there are a sequence of events has taken place and court's orders are also there.
On one occasion, this honorable court also observed that unless there is a legal hurdle, let them stay together. Lordship's order, my lord.
Learned counsel for the
Required to be together.
parties issued notice. Returnable 3 weeks. Mr. B. Chaudhary represents the respondents, all the respondents.
1, 2, 3, and 4, Lordship.
Any other respondent?
5, my lord,
Principal.
by registered post, and if lordship permits, Dusty also. That is the place I am required to join. They would have little to answer.
The writ petition is filed by the petitioner praying for setting aside from the order dated 24th January 2024, whereby the petitioner who was working as UDA in the office of the CDPO, Jalla ICTS project, Boxa district, was transferred and posted in the office of the principal BTRC, Boxa district, in the same scale of pay and capacity with immediate effect. Stop. The petitioner had earlier approached his court by filing WPC 3287 of 2021, putting challenge the earlier transfer order issued on 26th of February 2021, whereby he was transferred from which order did you put to challenge?
So first time, my lord, I had prayed for consideration of my representation. The first representation, the first order.
In respect of which
My
order
wife was being transferred, my lord.
Ah.
3287.
he had approached this court, praying for consideration of his representation, that his wife was posted at Jola ICTS project, and the petitioner and since there is a post of UDA accountant in the office of CTPO Jola having fallen vacant, a representation was filed by the petitioner requesting his transfer to the post of UDA in the office of Jola ICTS project, IE, which is the place where his wife was posted. So, considering the fact that the representation was pending, this court disposed of the writ petition with a direction to consider the representations submitted by the petitioner. Stop pursuant there too. Which order was passed earlier?
My lord, at page, the first order is at page 42.
42, yes.
42 onward, paragraph 5, where, my lord, I gave up my claim for a transfer, requesting them to retain my wife at her place of transfer, because on my request, they had transferred my wife. Then came at page
All right.
44, the
Then-
next petition.
Then subsequently, the petitioner again approached this court by filing WPC number
470.
470 of 2023.
Relevant portion at page 46.
The grievance before the court, grievance of the petitioner before the court is that the petitioner and his wife are posted at two different places, and they have a 9-year-old child whose care and education is required to be taken, and because of which the education and welfare of the 9-year-old child gets hampered. Stop. Petitioner also is required to travel several. And what is the distance
No, no,
between
At that point of time, it was 300 kilometers.
Huh?
300 kilometers was the distance
at
from
the
there.
relevant point in time? The petitioner had traveled more than 300 kilometers every time he wished to visit his family members. Under such circumstances, he had approached his court, praying for reconsideration of praying for consideration of his representation. Stop. This writ petition was disposed of on 1/2/2023 with the following order. Page 46, mark portion. Pursuant thereto, the then what happened?
Page 51, my lord. I was posted to Jala.
Pursuant thereto, the petitioner was
First of
posted to Jala by order dated 1st of March 2023. So, subsequently, by 10th of March on 2023, the petitioner was again, the earlier order was cancelled and he was transferred and posted to the office of CTPO Goresor, ICTS project in the Boxa district.
I approached this court.
Yes.
Page 54.
Petitioner again approached this court filing WPC 1620 of 2023 and this court while issuing notice by order dated 22/3/2023 state the order of transfer dated 10th of March 2023 transferring the petitioner from Udalguri Kolaigaon ICTS project to Jala ICTS project. Stop.
Then they withdrew it at page 28. Page 58.
Subsequently, pursuant to the order pursuant to the order passed by the court staying the impugned transfer order, the same was
Cancel.
cancelled and the petitioner was allowed to be posted in Jala. Then
The petition was closed.
accordingly, the petition was closed by order dated 4th of December 2023.
Hmm.
Several supervisors, including the wife of the petitioner, was transferred. Stop. The wife of the petitioner was transferred from Jola to Khoirabari. Jola ICTS project to Khoirabari ICTS project. Stop. The wife of the petitioner again approached this court filing WPC 7577/2023 and by order dated 22/12/2023, the writ petition was disposed of, directing the respondents to dispose of the representation stated to have been filed by the wife of the present petitioner, until such time the representation was disposed of. The said transfer order dated 4th December 2023 was stayed. Stop. Pursuant to the order of the court, by order dated 30th of December 2023, the petitioner's wife was transferred to Bojali ICTS project, Borpeta, where presently the wife of the petitioner is posted and has joined in his new place of posting. So, while the matter was situated thus, by order dated 24th of January 2024, petitioner was again transferred and posted in the office of the principal VTRC Forum, Boxa district, in the same scale of pay and capacity. Stop. It is this order which is presently being assailed in the present writ petition. Stop. A representation has also been filed by the petitioner before the Joint Director cum CHD, Women and Child Development Department, VTC Kokrajhar, dated 25th of January 2024, praying for cancellation of the said impugned order. So, it is seen that there is a series of litigations filed by both the husband and wife requesting for a same place of posting in view of the welfare of their child, who is stated to be about 9/10 years old. So that apart, this court, while disposing of WPC number 470 by order dated 1/2/2023. Observed that unless there are any legal hurdles coming in the way of its transfer to ICTS project, appropriate orders may be passed, keeping in mind the facts and circumstances of the case. Stop. It is seen that the authorities have consistently issued orders, either transferring the petitioner or his wife, overlooking the requests made by the petitioners, and also the observation made by this court by the order dated so. Under such circumstances, this court is of the view that till the next returnable date, the impugned order of transfer dated so and so shall be stayed. Stop. Respondents are permitted to complete their instructions and apprise the court. Stop. Is there any? There was a office memorandum with regard to
My
transfer
lord,
and
yes,
posting.
there is one, my lord.
Is it available?
Yes. Three-year recon. अच्छा,
एक नहीं होनी है, रख दो अभी और ये खिड़की खुलवा दीजिए. Hello.
the fourth paragraph, my lord. Henceforth, the concept of transfer season is introduced in consideration of some inevitabilities. The month of December and January would constitute the transfer season. The department directors should be competent to effect transfers and postings of government officials, having completed 3 years only. 3 years only during the transfer season. Any transfer outside the transfer season would require the approval of the
Department
honorable
submitted that in terms of the office memorandum issued by the department from time to time, transfers are effected ordinarily upon completion of 3 years. Stop. As is evident from the transfer orders, the petitioner has not completed the 3 years at any place that he was posted. Stop.
Lordship, another aspect will be the whether this OM is being followed by the BTC or there is another OM by the BTC.
Find out.
Lordship,
Find out.
that aspect.
You find out. Matter be listed after the returnable date. It's on 28th of February.
I'm obliged.
Steps on respondent number 5. Notices waived in respect of respondent 1, 2, 3, 4. As Mr. B. Chaudhary has appeared, however, extra copies be furnished within 1 week from today.
Obliged.
Right, please, your lordship. My lord, petitioner is serving as supervisor in Chala ICDS project, my lord. By the annexure, my lord, that is dated 4th December 2023, my lord.
Page number?
Is, my lord, 16. And her name is there, serial number 96, page 20, my lord. From Jala ICDS project to, my lord, Goreswar ICDS.
Serial number?
96, my lord, page 20.
96.
Tutumani Bhoya, from Jala ICDS project, my lord, to Goreswar ICDS.
Yes.
My lord, the mother-in-law of the petitioner is in bedridden condition, my lord. She is aged about 92 years. And her younger daughter is a student of class 3, my lord. And they are resident of, my lord, Jala, nearby the, my lord, Jala ICDS project. Now, my lord, she has been transferred to, my lord, Goreswar ICDS project, which is situated around, my lord, 130 kilometers away from her residence, my lord. And in view of above, my lord, she has filed one representation before the, my lord, the Joint Director, my lord, page 31, my lord. So, page 29, my lord. On 15th, my lord, December 2023, paying for stay of her transfer, my lord. And in the meantime, my lord, she also, my lord, filed application for, my lord, unleave, and she is on leave, my lord, till yesterday, my lord. And annexure 6, my lord, dated 24 January 2024, she has been granted, my lord, unleave till yesterday. And my lord, since the earlier representation has not been disposed of, my lord, she filed another representation that is.
Your husband is also there, na?
Husband is also.
What is he doing?
He's a businessman, my lord.
Then
But my lord, the mother-in-law, who is aged about, my lord, 92 years.
find out.
She is in bedridden condition, my lord. Due to, my lord, her shoulder and hips were broken in an accident. And we have annexed, my lord, the certificate issued by the doctor, my lord. It is 26, my lord. Some problem will arise, my lord, because since the, my lord, Goreswar ICDS project is situated in 130 kilometers away, she had to reside in Goreswar for discharging her proper duty, my lord, leaving her family in Jala, my lord. So, my lord, she is praying for before the authority only to consider her prayer, either to continue, allow her to continue in Jala ICDS project or at any nearby, my lord, ICDS project,
When was the order passed?
my lord.
When was the transfer order passed?
My lord, 4th December, my lord, that is, my lord,
And when did you file
16.
your when did you file your representation?
on, my lord, 15 December 2020, first representation was filed, my lord, that is 29. And second, my lord, is on, my lord, 24 January 24, that is Annexure 7, page 31.
You are entitled to leave, aren't you? Leave.
My lord, that is, my lord, Annexure 6, I have been granted, my lord.
Then
My lord, till yesterday, my lord. And today onwards, I have to, my lord, join in my duty. And there is, my lord, every possibility to, my lord, release me, my lord, from Jala ICDS project.
yes, Mr. Chaudhary.
Lordship, it seems that from that office, no one is eager to be transferred out from that Jala project, Lordship. It seems that no one is interested to to go out from that project. And since she has filed 2 representation, Lordship may direct a week's time to dispose of this
All right. Heard,
representation.
learned counsel for the parties. This writ petition is filed by the petitioner putting to challenge the order dated 4th of December 2023. Insofar as the writ petitioner is concerned, whereby she was transferred from page number,
Page 16, my lord, Annexure 1.
no name of the petitioner, where is
Page
it?
20, my lord, serial number 96.
Whereby the petitioner was transferred from Jala ICDS project district Boxer to Goreswar ICDS project Tamulpur. What is the distance?
130 kilometers, my lord.
The grievance of the petitioner is that she has 2 minor children, and her mother-in-law, who's aged about 92 years, is suffered injuries on her left shoulder and hips, suffered fractures on her left shoulder and hip, and is bedridden and is required to be under constant medical treatment. So, under such circumstances, the petitioner has represented before the Joint Director, Women and Child Development, BTC, requesting for reconsideration of the transfer orders issued. The first representation was filed on
First representation on 15/12/2023,
15/12/23.
my lord.
Since no reply was received, the petitioner filed another representation dated 24/1/2024. However, till date, no response has been received from, no reply has been received from the Office of the Joint Director, Women and Child Development. Stop. Para Mr. B. Chaudhary, learned counsel for the petitioner, submits that he has no instructions in the matter, but considering that the 2 representations are pending, the matter can be disposed of. Expeditious, directing the department to dispose of the representations expeditious. Having heard the learned counsels for the party, and upon and taking into consideration the submissions made by the learned counsels, This writ petition stands disposed of with a direction to the Joint Director
Permanent, well,
Joint Director and Chief Head of Department, Bodoland Territorial Council. Number 2,
my lord. Respond number 2.
respondent number 2, who will look into the grievances of the petitioner, stated to have been placed by way of the representations dated 15
15/12/2023 and
23
24.
and 24/1/2024. The respondent number 2 will thereafter pass appropriate orders in the matter, taking into consideration the grievances raised by the writ petitioner. Stop. The matter be considered and disposed of within a period of 10 days from the date of receipt of a certified copy of this order. Till such disposal, the petitioner, the impugned order dated so and so, passed by the
Respond number 2, my lord.
respondent number 2, insofar as the writ petitioner is concerned, shall not be given effect to. So we make it 1 week, 7 days from the date of receipt of a certified copy of this order. The respondent counsel is also permitted to furnish a certified copy of this order before the competent authority. Writ petition stands disposed of in terms of the above.
Obliged.
In this case, your lordship kindly perusing earlier order dated 18/12/2023, your lordship. Last paragraph. Mr. B. Gogol, Learned Standing Council Finance, has placed the communication dated 14/12/2023 and submitted that the proposal contained in e-file number so and so is under active consideration of the department as the matter requires proper evaluation for sanction.
But on 20th/12, it has been sanctioned. On 20th/12, the proposal has been sanctioned.
Saying on
Yes.
28/12.
20th/12.
Okay.
May I point out? Madam?
Including this 421.
No, your lordship. This is the advertisement, your lordship.
No, it's a
Advertisement
1-to-1/6.
published on 17 January
It is 1-to-1/6.
2024.
It is 1-to-1/6. Well, last year, my lord, it says, my lord, the finance SI approval one 28/12/23. So that number is there. Whatever proposal was submitted, my lord, we have sanctioned.
1216 numbers of posts.
Yes.
This is for filling up.
On 18/12/2000.
This is for filling up.
Lordship. No, that was the proposal they submitted, we have sanctioned it. Well. Now BTC says that, my lord, from this particular post, they will, my lord, accommodate the.
Yes, who's
some
for
of the
BTC?
requisition left out. 422 maybe.
On 17 January 2024, the BTC has published advertisement, your lordship.
You see the advertisement? We have sought for certain posts for sanction. That is 12, and then the SIU approval was given for 1216. And out of which
as the 416 persons are there who have not received the sanction. The process is on, the scrutiny is going on. Thereafter, the appointment will be made.
No. This sanction is for what? Fresh appointment.
Sanction has a, there will be fresh appointment as well as the person who are in this particular petition, which amounts to 421 persons are not there who have not been taken into service. That also, it will take care of 421
The
persons.
grievance of the petitioner is for release of salary, isn't it?
It's a something is, that is salary is the second part, my lord.
Huh.
Some of them are not even getting salary, some have not been sanctioned, and the sanction first we need to get a sanction. Sanction has been granted. Now we'll taking the process. Those persons will be accommodated, my lord. Reinstituted in their
No, it's not clear. What is that proposal? What was the proposal sent?
proposal for sanction, because some persons are appointed at non-sanction post.
No, sanctioning of what? Posts.
Yes. This is sanction for LP and UP schools.
This sanction is granted towards filling up of these posts,
Yes.
vacant posts,
LP and UP schools,
as per the proposal.
as per the proposal.
So what was the proposal? Do you have a copy?
Not sure. In fact, there is a bunch of papers, my lord.
They just give us the proposal.
Not sure.
The proposal will contain a forwarding
Yes, my lord.
note.
That is
We want to see that what was the proposal about.
Oh.
This is for filling up.
This is finished.
That has been-
Then for sanction and opening up. Then sanction has been granted
Huh.
by the SI approval, Finance Department on 28/12. Subsequently, the Secretary to Government of Assam, the Education Department has given this approval, my lord, on 29, next day, my lord,
Hmm.
for filling up this post.
Yes.
Filling up this post, and among these, the petitioner, there are 421 are there, which not been taken into, they have not been accommodated. These persons will be accommodated, and remaining posts will come for advertisement, and advertisement already been government had been published, my lord, with a clause that in clause number 17, my lord. Yes, the vacancy may vary due to administrative reason and a matter under sub judice before the High Court.
How many writ petitioners are there presently?
My lord,
In the entire bunch of cases, how many writ petitioners?
how many? Total number of petitioner is 1317,
Hmm.
out of which 892 has already received their salary and they have joined. Current salary. And 421 have not been able to, because there is no sanction. So that sanction we have received. They will be now with scrutiny,
Yes.
scrutiny, and they will get it, the sanction, after sanction.
What do you say?
Yes, your lordship, kindly perusing your lordships order 18/12/2023, your lordship. What they have submitted before this court, your lordship.
Yes.
Mr. B. Gogoi Learned Standing Council Finance has placed the communication dated 14/12/2023 and submitted that the proposal contained in e-file number 259464 is under active consideration of the department, as the matter requires proper evaluation for sanctioning of the proposal for filling up 1216 number of posts of assistant teacher under BTC area. It is submitted that 421 teachers who have claimed to have not received any salaries are also included within this 1216.
Yes.
The 1216 number has already approved, your lordship. It is sanctioned,
Yes.
and numbers of assistant teachers under BTC area. He therefore submit that If the department decide to approve the proposal, then the payer for release of salary, including the 4-1 teachers, will be covered.
No, we want to know how many petitioners are here before the court. How many petitioners in total?
Lots will turn to order dated 15/7/23, my lord. Sorry, 25/7/23. In paragraph number 40, it's absolutely clear, my lord. Paragraph 40.
कहाँ से आ रहे हैं? कहाँ से आवाज आ रहा है बोलने का? सुनाई नहीं दे रहा? Okay. So now what will be the next step?
Next step, the advertisement has been issued, my lord. These posts will be filled up.
No, but
And we are-
how will you fill up these posts?
Posts will be filled up by advertisement.
Ah.
As the remaining posts, there are 421 persons. We are scrutinizing it. So then the appointment will be done. These persons who have already filed a petition, we are scrutinizing the legality, validity, and will issue appointment letters accordingly. And advertisement will take up care of the remaining rest of the sanction post.
No, no. If you come to order dated 25/7/23,
That's it.
there who are the writ petitions, the number of petitioners are indicated.
That's it.
So all these petitioners have come up with a grievance that their salaries have not been released.
Some salaries, some are not appointed. Some there are different type of players are there. So we have taken, we received a sanction for 12/16. So their petitioners will be taken care of, as well as the other person, the advertisement is issued by them. We will specially apply and everything.
So you are saying that all these petitioners fill up 1-1 6 posts? No.
No, 421. Only 421 remains from the petition. But we have not till now not been accommodated. Race one, earlier also we got a section out of which 892 had already been in receiving salary, and they had been given the appointment.
Yes, petitioners, we'd like to know how many of your petitioners have been receiving salaries. Where is that list?
The total numbers of petitioners, your lordships, 1317.
Yes.
Entire sees your lordships.
Hmm.
And during pendencies of this case, your lordships, the 892 numbers of petitioners has been receiving current salaries, your lordships.
So what are your prayers in the writ petition?
That is payment of current salaries as well as area salaries, with effect from October 2015.
Now, vis-a-vis the prayers made by this sanction order, what are you proposing to do? Are you giving them area salaries also?
No, area salaries, let appointment come. Earlier person's appointment has been made in prospective terms, not the area salary, only prospective from the date of the order. And subsequently, we are scrutinizing the rest of the person 421, and we will issue appointment order, my lord. Let the scrutiny continue, my lord. In the meantime, we will appoint all the person. From now, we have received the sanction post, and we will appoint them accordingly.
No, there is something not very clear. You see, the petitioners, some of the petitioners are receiving current salaries,
Yes,
which means they are working.
working.
Now they are also praying for area salary.
Lordship will not dispose of it. Keep it pending, my lord. Area will they will make the argument, will make the argument. In the meantime, the sanction was not there, sanction has come. So the appointment process,
No, the sanction is for appointment.
yes, that will, in the meantime, we are scrutinizing everything, the documents, those persons who are working genuinely, they will get the appointment. As well as remaining post for
No,
that advertisement has come.
appointment retrospectively.
Well, that I can say now, my lord, that
Then?
let the order come, my lord.
What order?
That appointment order, my lord. The earlier it is that 898% there prospectively appointment has been done.
No, Mr. Gogoi, what
Actually,
what
what
proposal
has
have you
happened-
sanctioned?
Well, as per their proposal, my lord, of 1216, we have already sanctioned all the, my lord.
No, you have sanctioned, but what have you sanctioned? Do you have the sanction order?
Sanction order is not there, but it is mentioned, my lord, that file
It is
number is
sanctioned.
there.
Right.
It is,
So-
my lord, E259464.
That has been sanctioned.
Right.
The proposal is for filling up 1216 posts.
Yes, madam, yes. Now, what the BTC is now proposing is that, my lord, out of this 1216 that has been sanctioned by the finance department, they will be accommodating this, my lord, to 422, 21 from this particular sanction post. Difficulties, my lord, that all these appointments were illegal appointments. They were terminated. Subsequently, my lord, pursuant to a policy decision of the BTC, they were again, my lord, inducted in the service. But because, my lord, there was no sanction post from 2005 or so, my lord, of 15, 15. From 2015, my lord, till that they are not receiving the salary. In between, they are trying to regularize this by my lord, sanctioning this particular post, new whatever post is available, where they could be accommodated. A batch have now been accommodated, they are getting the current salary.
No, they could be accommodated retrospectively.
That part, my lord, issue will again come, but at least let them have the current salary, my lord. They are not getting any, not a single penny, my lord, from their date of their regularity. The area salary part will come again, my lord. But as of now, my lord, the endeavor is to, my lord, release the current salary.
Yes, what do you say?
Because some are getting, my lord.
Item number 42 and 43, these two cases filed only on 23, and they are receiving current salary after accommodate in a sanction post, and they are claiming the repetition only for area salary from 2015, where from they were reinstated. So my case is not same as in other cases. They have filed only on 23 minor and their prayer is for area salary. They are receiving current salary. And they have already accommodated in the sanction. These two cases may be hard and separately.
BTC and finance, or maybe BTC, Mr. Bora, you prepare a chart on the basis of the petitioners. How many petitioners have received their current salary and how many are preparing for area salaries?
Absolutely.
We are requesting the standing council because this ought to have been submitted by the petitioners, but they are not doing it.
Your Lordship, you have submitted it. In respect of my case, that is
No,
11
not your case. We want the total number of petitioners here who are praying for current salary, or what are their grievances and why this entire bunch of cases have been listed together if the prayers are different.
Your Lordship, the issue stands on a similar footing. First of all,
It cannot be similar footing. It
why
must
I'm
be
saying
one
so,
issue.
Your Lordship, in all the cases, the prayers are for releasing of the area salary. For current salary, wherein they have been working since 2015, 1st October 2015. In 11, 12, 13, 14, and 15, I don't know about the other cases. Here we have made a prayer, as we have been reinstated in our services by order of this court, wherein a policy decision was taken by the BTC. So therefore, our services should be count for service benefits from the year of our initial appointment. That is 1999. And if your Lordship remembers, an argument was made to that effect by one of the counsel, Mr. M. Goswami, to that effect.
But however, they were reluctant to do the hearing on that day.
That is what we are trying to understand.
Yes.
The sanction which has been granted is for appointment to the post. Assuming these appointments are made, how does it give you? How will the government consider your praise for arrear salary? Your arrear salary will relate back, which you are claiming,
Right, Your Lordship.
to your original date of appointment.
Correct, Your Lordship.
Now, if these appointments original orders are not there, and it starts from a prospective date, you are entitled to whatever salary from that date.
But as of now, Your Lordship, the understanding was that when the order was
So
passed.
there can't be any understanding contrary to law.
No, the issue was like this. They will sanction 1216 posts. They've made a statement before this court, which has been recorded by this court. I'll demonstrate it. 421 posters are meant for all those persons out of these total petitioners, all the batch of petitioners. Out of these 1317 petitioners, 421 petitioners have not received their salary. So as soon as
They have not received their current salary.
since 2015 to till date, after their reinstatement.
No. That's not right. 421 have not received because there was no sanction. Sanction now it has come.
But they
Now
have
the
been
appointment
reinstated
has
with
come.
the
Yes,
services.
earlier sanction 892 has already been appointment has been given and they are getting regular salary. Lordship will turn to the order that order dated 25/7/2023, my lord. Justice Amar Pathak's order, my lord. Paragraph number 40. It's absolutely clear, my lord.
Okay. Hard learned counsel for the parties. Give the name. You give your names in the chat for all petitioners appearing for various writ petitioners. Pursuant to orders in deference to the orders dated 18/12/2023 passed by this court, Mr. B. Gogoi, learned standing counsel, as well as Mr. S. Bora, learned standing counsel, PTC, Mr. Gogoi Finance, has submitted before the court that the proposal placed before the Finance Department by e-file number 259464 has received the sanction. Pursuant to the sanction received, the Secretary to the Government of Assam, Department of School Education, has informed the Director of Education, PTC, to take necessary steps has informed the Director of Education, PTC, conveying the approval of the government for filling up 1216 numbers of vacant posts of LP and UP schools, within bracket LP 822 and ME 394 numbers in the PTC area, as per the proposal put up by the PTC, subject to the conditions mentioned in the same communication. Learned Standing Counsel for the PTC, Mr. S. Bora, submits now that the proposal has been sanctioned, has been granted approval, and the communication has been made to the PTC areas, PTC authority. The department has now taken steps to fill up 1216 number of vacant posts in LP and UP schools. He therefore submits that the process of recruitment, process of what? Filling up.
The verification of the petition as well. This petition.
The necessary steps required to be taken by the department is underway, and he therefore prays that the matter be listed after 4 weeks to enable the department to apprise the court as to the steps taken pursuant to the sanction of these 1216 number of vacant posts. Submissions made by the petitioner respondents are not objected to by the counsels for the petitioners. Therefore, the matter stands referred to be listed again after 4 weeks on a date to be fixed by the registry.
So lordship may indicate one thing that, as regard, we have said with respect to the petitioner, can it be respect to 421 petitioners who are not receiving their current salary?
No, we can't. Whatever is there is there. It's not there about 421 in the sanction order. We have just quoted the sanction order. This 421 is on the basis of their oral prayer. Let the matter be listed. Then we'll see what steps have they taken.
That in my
But-
case,
But I don't see how your current salaries can be prima facie be released on the
Like this-
basis of this sanction.
Dear my lord, if the regulation order shall come into force with prospective effect. That means their area salary maybe
Right.
granted.
Right.
My prayer is, in this two writ petition, the prayer is for.
No, pertaining,
Segregated from
no,
this-
pertaining to the same,
No, my lord.
same area.
No, he says this case are different.
Different. So the mathematics said
Okay.
Item number.
MS,
42 and 43.
item number
42 and 43.
42 and 43. Item 42, 43, at the request of, as per the submission of the learned counsel for the petitioner, MS A. Puzar Borua, and which is not disputed by the learned standing counsel, Mr. S. Bora, the issues involved in the writ petition are only with regard to area salary
Area salary.
to the petitioners in respect of their services rendered as
As assistant teacher, my lord.
assistant teachers
LP school, my lord,
in LP schools
under Baksa district.
under the Buxa district. It is submitted that these issues are different from the issues raised by the various petitioners in this particular series of cases. This stop prayer is therefore made for segregating these two matters. Prayer is not objected to by the learned standing counsel. Accordingly, item 42 and 43, being WPC 1860 of 2023 and WPC 1904 of 2023, be segregated from this bunch of writ petitions and be listed separately
After 2 weeks.
after 4 weeks.
I am in 46 and 47 years old.
Can it be taken up next week? Mr. K. Gogoi will apprise the court.
What is the issue about it?
Issue, your lordship, is like this, your lordship. There are, your lordship, so far as there are two colleges are concerned here, your lordship. One is Jorhat Institute of Science and Technology, and one is Vineshwar Brahma Institute of Engineering College, your lordship. Now, your lordship, in these two colleges, your lordship, initially both of these were government, your lordship, colleges, but subsequently, your lordship, in the year 2009, your lordship, they were brought under, your lordship, society mode. Government created a society, your lordship, with the government officers, your lordship. And your lordship, in the meanwhile, your lordship, in 2009, we were appointed as a, your lordship, assistant professor in various departments, your lordship. Now, when we were appointed as assistant professor, your lordship, we are continuing with our service, your lordship. In 2016, what government did, your lordship? Government take over the administration of these two colleges again, your lordship, in their hand, your lordship. From society mode to became, your lordship, government. They came under the, your lordship, control of the government, direct control of the government. And while doing so, your lordship, what they did, your lordship, they regularized our service, your lordship. There is no reason for regularizing our service, your lordship. And your lordship, while regularizing their service, they refixes our salaries also, your lordship. Now, your lordship, as a result of which, your lordship, our salaries got reduced, your lordship. So far as these petitioners are concerned, their service seniority, your lordship, in that particular college has gone, your lordship, since, your lordship, from 2009 to 2016, 7 years of seniority they have lost, your lordship. And in view of that, your lordship, they preferred this petition.
Where are your initial orders of appointment?
Your lordship will get it, your lordship, at Advertisement, your lordship will get it at page 20.
Page 20.
This is for Jorhat Institute of Science and Technology. Your lordship will kindly see the third paragraph. Application forms are obtained from the office of the Directorate of Technical Education, Assam, Kahilipara, and nodal officer of society for requisition. This was on the behalf of the society, your lordship. Issued by, your lordship will get it at page 20D. Director of Technical Education, your lordship. Now, page 21 is your lordship, Vinesh Brahma. And our appointments are, your lordship, at page 23 onward. Appointment orders were issued by the Additional Chief Secretary, your lordship, to the Government of Assam. Page 21 onwards, your lordship.
Mr. Gogoi is arguing the matter.
We have some urgency, your lordship, in this case, your lordship.
At the request of Mr. A. Tovildar, matter stands, who submits that Mr. K. Gogoi, Lanet CGC, is required to address the court in behalf of the respondent. Prayer is made for adjournment of the matter. Mr. S. Botakur, learned counsel for the petitioner, submits that there is some urgency in the matter. He requests for a early date.
On 8th, your lordship.
8th, you think it, no? Partner matters, meeting matters, okay. All right, let's keep it on 8th.
Deeply obliged, your lordship.
Obliged.
Yes.
Yes,
In this matter, my lord, the pleadings are complete. The issue is whether, my lord, the petitioner will be covered under the old pension rules or the new pension scheme. It will require some length of hearing.
no, what about Purnima Hore
Purnima Hore is there, my lord.
is covered by the matter?
Purnima Hore does not cover me because lots of the learned, this writ petition was also listed along with a bunch of other writ petitions. The Honorable Single Judge on his own said that my case does not cover in any of the categories. The learned Single Judge therefore lordship segregated this case on his own lordship because there is a proper advertisement and we were appointed in 1993-94. And lordship, our regulation also was done in 2006
You are working as what?
as assistant teacher
Assistant teachers.
in ME and MB school. We are appointed following an advertisement of 3/9/1991. lordship.
All right, you submitted that. Item number
49.
49.
In fact, lordship, in my affidavit and reply, I have annexed one order passed by the honorable court.
No,
My
if the
case is
pleadings
covered by that
pleadings are complete, then we keep it for hearing. Yes,
admission hearing. lordship.
not admission hearing. There's no admission hearing like this. If it requires hearing, then it will have to be heard.
Because, my lord, what had happened, my lord, in Purnima Hore's bunch of cases, none of the petitioners has challenged the new pension scheme as such. But here is a case before my lord, where, my lord, the petitioner has challenged the new pension scheme also. So I need to, my lord, defend it.
They have already filed their affidavit. lordship.
And we have filed it, my lord. It
And
will
I have filed
require
my
full
reply.
length hearing, my lord. I am otherwise ready.
No, if you are ready, then we can hear it. If you think that the matter is required to be heard, it will be heard.
Lordship can keep it for my lord, final disclosure, my lord. In the hearing column, my lord.
Heard learned counsel to the party that is that the pleadings are complete. Better be listed for hearing.
I'm obliged.
So,
Lordship may kindly give a that
March,
March. Fix that one.
no fixed date. Will come for hearing.
Okay.
You mention and we'll take up the matter.
Second, you could mention for second, you could mention for the book for the doctor.
Yes.
My lord, here in the case, my lord, the petitioner is the legally married first wife, my lord, of a person who was working. And she was been not given, my lord, the compassionate pensionary benefit, my lord. So, my lord, what happened? Lordship kindly have a look, my lord, that 9-4. We obtain all the necessary document, my lord, that certificate, including, my lord, in certificate. We approached to the authority, my lord, and we submitted our all the required documents.
Yes. Then
That has not been considered, my lord. Thereafter, what happened, my lord? Another communication was made, my lord, at page 36.
page
36, my lord. This
Ah.
is the subsequent communication of the kin certificate, my lord. Lordship will see page 36. With reference to the subject, I have the honor to inform that as per the field inquiry, so and so, it was found the deceased so and so Mala, permanent resident of Revenue Circle under Brogane. But it is the next kin certificate as this is known. No Betty Award number so and so Revenue Village. The certificate was issued on the report of Morigaon Revenue and the name of Gita Mala's second wife and her son Gita Malo was excluded from the certificate. To that effect, my lord, while issuing notice, Honorable Court was pleased to ask, my lord, Lordship kindly have a look to counter that, my lord, Lordship. Order dated, my lord. Order dated, Lordship will see, order dated, my lord, 6/4/23, my lord.
6.
6/4/23.
There is no 6/4/23 yet. 24/3. 23. Then
Then, my lord,
26.
they, maybe in other case, second one,
Yes, now,
51.
yes.
Just property part, my lord, last second paragraph. On the returnable date, learned counsel appearing on behalf of the respondent shall apprise the court on what basis of which the communication was issued by the respondent number 3. Please the matter along with. So we had to file 2 writ petition, my lord. One is seeking pension and one, my lord, challenging the very communication date. So happened. So we had to file 2 writ petition, my lord, one challenging the subsequent communication in respect of the communication, my lord, wherein it has been asked to add as a second wife in a legal heir, my lord. That cannot be, my lord.
Communication issued by the subtle officer.
My lord. Then lordship will see the affidavit filed in the first case by the government, my lord. Respondent number 4, my lord.
Yes.
That, my lord, at page 50 of the first writ petition, my lord, affidavit has been filed, my lord, forwarding why I have been delayed, my lord. Page 49 and 50, my lord. Page 49, it says, my lord, in respect of WPC number, the petitioner submitted relevant document with the next kin certificate showing phone numbers of family members of so-and-so pensionary. But in the meantime, second wife, Govinda Chandra Malo, submitted a petition to BO Morigao regarding she also legally second married wife on son and so was not included in the next kin certificate which is submitted by the petitioner for pensionary benefit copy and close. In this regard, the respondent number 6 forwarded a letter so by the letter number so. Late Govinda Malo have 2 wives along with their children, but next kin certificate shown only
Do you
first
have a marriage certificate?
marriage, my lord. During that time, my lord, it was not.
So who issued the
Next of kin certificate is there.
who is issued the next of kin?
That your lordship will see at the deputy commissioner, my lord.
Who's for the deputy commissioner?
Yes, my lord. At first read petition, lordship will see at annexure 2, my lord, at page 31 and 32, my lord.
On what basis deputy commissioner has issued the next of kin?
On the basis of the application, my lord. So because after the death of the employee, my lord, the wife of the deceased, my lord, along with the legal heirs, they make an application.
No, is there any nomination in the pension papers which are submitted? Any nomination? Yeah, who's for the education?
My lord will see
Was there any nomination by the deceased employee for pension?
Law does not permit, my lord, no status for the second wife. To that effect, I got the judgment of the apex court also, and various honorable high court also held that, my lord.
That is what we want to find out. Who's the first wife? Who's the second wife? On what basis this has been
I am
done?
the first wife, my lord. They have not denied.
No, you're the first wife. We want to know from the DC how this has been
Yes.
decided. On what
Yes,
basis?
that one.
My lord,
My lord, on the second case, my lord, the honorable court was pleased to ask, my lord, under what circumstances the second kin certificate, my lord, communication, my lord, it is not it was issued.
Who is for the second wife?
Second wife, my lord.
You are not entitled otherwise.
I'm not entitled also, I have filed affidavit, but I am having a mentally retarded and physically handicapped child. So in view of the amendment of this 2018 rule lordship, my child is entitled. So that is only my claim.
Okay.
To that effect,
Have you enclosed the rule?
Yes. In my lordship, may kindly have the affidavit filed by the respondent number 11.
Was issued, my lord.
No, lordship already, I will commit to that. This affidavit lordship by respondent number 11. I have quoted the rule. Now, prior to that, lordship, if annexure 1, sorry, page 49, this is the certificate issued from the concerned authority, whether the 50% lordship, disabled lordship, page 49.
Lordship, can you have a look the date of that certificate?
Yes, date of the certificate 8th of February 2020.
After filing the writ petition.
Yes, when I received the
Are you questioning the authenticity?
lordship,
my lord, he did not submit, my lord, birth certificate. First and foremost thing, my lord, let him annex or show, my lord, that he was my son. Suddenly, my lord, after getting notice, they cannot come with a, my lord, saying that he was the son. And that to obtain just
So
on
in my affidavit, I've
August month.
stated that in the NRC lordship, under clause 4, so and so, our name have been recorded as husband, wife, and son. If required, a child produced lordship. I've already stated in paragraph 3.
Yes.
And when I received this notice of the repetition lordship, then I applied, then I also filed application before the deputy commissioner. But till that, they have not taken any decision. But so far, my right is
Who
concerned,
is to release the pension?
director of pension lordship.
Who is the authority who will decide who is the first wife, second wife? Block
the-
elementary.
That is the deputy commissioner.
Block elementary.
No, my lord, it has to be decided by the deputy commissioner, my lord, when issuing the kin certificate.
Who is to decide the entitlement of pension?
Pension, my lord, is the director.
Director of pension.
Director pension with
Is there, who's for the education department? Have we submitted the proposal?
That proposal could not be submitted because of this dispute, madam. Because second, that nesting certificate, son of the second wife is not included. That's because of this.
Who is to include it?
Madam.
Who will include it? You take a decision and make necessary changes. It is your duty to make take a decision.
Already application also filed before the DC lord.
You have to take a decision.
No, my lord.
Yes, my lord, that nesting certificate, the son of the second wife was not included. So department could not.
If it
Where
is
is the
not
law,
there,
man?
then why did you not process the pension papers of the first wife? Why are you holding on to it?
My lord may direct.
Where is the question of direction? It is your duty.
My lord, because of that second wife, son also entitled. So
Where is that order?
No.
Where is that order that you are unable to process the pension papers? Where have you stated it?
my lord, in our affidavit, my lord.
Show us.
My lord will, my lord, lordship kindly have a look at page 51, my lord.
Wait, let us go through the affidavit first.
Yes, my lord. That is the core issue, my lord. Page 51.
Who is supposed to give the report? BEO. Where is the BEO?
Here, my lord, page 49, my lord.
49. Yes.
My lord, in this regard, stated that Govindo Chandra Mallo have two wives, but the petitioner is the first wife. She submitted next kin certificate only petitioner's name and her children, but she did not include the second wife and her physically handicapped son. So respondent number 7 issued a letter by my lord as annexure D to petitioner that the next kin certificate should be submitted the BEO Lahore, including the name of second wife and her son, but the petitioner till today unable to submit the same, for which BEO Lahore is not able to submit the pension proposal of the
But
petitioner.
why are they waiting there? Who submitted the next of kin certificate? Which next of kin certificate?
First wife had submitted. madam.
Where is that next of kin certificate?
My lord, at page, the first petition at
Page 31, my lord.
31,
31.
my lord. Operative is 30.
31.
31, my lord. 31, 30.
31. Yes, then?
The next page 32 will see lordship.
No, we have seen it. Now in the BEO report, what have you stated?
That second wife son was not included in certificate, so could not able to finalize.
No, why will she include it? Where is that report of that circle officer? Where is the report of the circle officer?
My lord, page 36.
30?
36.
36. Yeah, who's for the DC?
Communication.
You have to take a decision here now.
Yes, ma'am. On the basis of this, page 36, my lord, it is up to the department to send a proposal to the pencil.
No, you have to first, you have to decide whether the next of kin certificate at page 31 is required to be retained or cancelled.
Oh, 32.
You have given a report. This next of kin certificate is on 4/2/2022.
My lord, I got it.
And the report is on 3/9/2022.
My lord.
Now, if the report says this, then what is the significance of the certificate? Have you filed any affidavit?
My lord, deputy commissioner is not made a party here, my lord. So, my lord, let me get that.
Deputy commissioner not made a party.
My lord. Nine. Nine. In my petition, it's not there, my lord.
Circle officer is there.
Circle officer is there, my lord.
The inadequacy of representation of SCs and STs is a basic requirement for providing reservation in promotion, as laid down by the court in M. Nagaraj. The unit for the purpose of collection of data is a cadre. According to M. Nagaraj and Jarnail Singh, for the purpose of collection of quantifiable data for providing reservation in promotions, the entire service cannot be taken into unit and treated as a cadre, as already stated. The structures of services in the state of Karnataka is along the same lines as that of the services in the central government. Services are divided into groups, which can further be bifurcated into cadres. There is no confusion that a cadre is not synonymous with a group. The first term of reference for the Ratnaprabha committee was to collect data cadre-wise. The conclusion of the court in B.K. Pavitra that the expression cadre has no fixed meaning in the service jurisprudence is contrary to the judgment of this court, which has been referred to above while answering the point. In clear terms, M. Nagaraj held that the unit of collection of quantifiable data is a cadre, not service, as has been held in B.K. Pavitra. Article 16(4) of the Constitution enables the state to make reservation in promotions for SCs and STs which are not adequately represented in the services of the state. However, the provisions of the reservation in matters of promotion is with reference to class or classes of posts in the services under the state. That groups consist of cadre is a fact which was taken into consideration by this court in B.K. Pavitra. The conclusion that the collection of data on the basis of groups is valid is contrary to the decisions of the court in M. Nagaraj and Jarnail Singh. The state should justify reservation in promotions with respect to the cadre to which the promotion is made, taking into account the data pertaining to a group, which would be an amalgamation of certain cadres in a service, would not give the correct picture of the inadequacy of representation of SCs and STs in the cadre in relation to which reservation in promotion is thought to be made. Rosters are prepared cadre-wise and not group-wise. Sampling methods which was adopted by the Ratnaprabha committee might be a statistical formula appropriate for collection of data. However, Lord, this is important. The purpose for the collection of quantifiable data to assess representations of SCs and STs for the group of providing reservation in promotion, cadre, which is a part of a group, is the unit, and the data has to be collected with respect to each cadre. Therefore, we hold that the conclusion of this group, if this court in B.K. Pavitra approving the collection of data on the basis of groups and not cadres is contrary to the law laid down by the court in M. Nagaraj and Jarnail Singh. It is made clear that we have not expressed our opinion on the merits of any individual cases, as we have only answered the common issues that were formulated after hearing the parties. So, my lord, the entire contention was that, my lord, that the OM of 2018, 2023, 18/1/2023, now bifurcates the groups and takes the entire unit as a service, which is contrary to the judgment as held in this Jarnail Singh, and this was reiterated and upheld in the division bench of this Honorable Court.
Yes.
Another judgment is R.K. Sabharwal, my lord.
1 minute, 1 minute. Yes.
My lord, if for a moment, if I can take my lord again to the impugned OM dated 18/1/2023 to show that, my lord, this is now contrary to the judgment of the Supreme Court in General Singh 2, where, my lord, they have created group and taken the entire service into care.
Page number?
Just a minute. It starts from 107, my lord. Annexure G. Office Memorandum dated 18 January 2020.
Yes.
If I may take my lord to the impugned clause, that is at page 108, subclause 4. A, if I may read, my lord. In case of promotion in Group A service, the quantum of reservation for SC, STP in promotion shall be as per stipulated percentage of reservation available for these categories. However, SC or STP or STH government services in Group A services on their accelerated promotion by virtue of rule of reservation shall not be entitled to consequential seniority. The application of general catch-up rule will allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional post. Only they are promoted to the same cadre as the officer of reserve category, provided the officer of the reserve category had got his promotional ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre. Seniority of government services in Group A services shall be revised accordingly as per our principle. Further, an officer promoted from Group B to Group A services will also regain his seniority in Group A services on promotion vis-a-vis his compatriot in Group B services, provided the officer was senior to the reserve category officer in the particular Group B cadre prior to the promotion of the reserve category.
Your submission on the last occasion was catch-up rule has been done away with.
Yes, that has been.
As per which judgment?
85th constitutional amendment. Thereafter, it does not exist because there is an OM also. Your lordship has referred also that OM, that is at page 44 of this company, this writ petition.
Writ petition,
Yes,
44.
Yes, page number 40.
That is at 2001 or 2?
My lord, that is of 1996.
96.
Yes, my lord. There they state that they have given in terms of Virpal Singh Chauhan. Pursuant to this, my lord, the 2002 OM came in, wherein it has been stated that this OM of 1996 has been withdrawn as if it was never issued. So, my lord, for a moment, if I take my lord at page 44, that is the OM of 1996. Page 44, my lord.
Yes. This was withdrawn by 46.
This was withdrawn by 46, my lord. So, my lord, the single judge in Bhagwan Patta's case held that since 2002 is still in operation, the consequential seniority, which is discernible and flowing from Section 5 of the Act.
Is it your submission that now the attempt by the respondents to bring in this catch-up rule again is contrary to the law?
To the General Singh, where it says it has to be cadre-wise, promotion has to be made to the reserve category candidate, and till
but General Singh does it the catch-up rule? General Singh is to define that instead of groups, it should be catered. Not the entire service taken together. The quantifiable data is not required to be found out. It has to be done stage-wise or post-wise. I mean, cadre-wise. Now, where is the issue of catch-up rule not being there?
Yes. Milord, catch-up won't come in for two reasons. One, Milord, that 2002 OM till today has not been written. Milord, two principles cannot go together.
No, we want to understand the principle. Forget the OM for the time being.
Yes,
but is it a case that only in view of this OM they cannot go for catch-up rule? Is one argument. The other alternative argument could be that 2002 is issued after the correction has been made by the subsequent judgment where Virpal was overruled or
Overruled and the
then
amendment came in, my lord, and the
amendments came
OM
in.
was issued of 2002.
That position still remains.
So, my lord, here I'll like to clarify, my lord, that the judgment of Bhagwan Patel, my lord, it says the most pertinent paragraph which is also mentioned in the OM, which is, my lord, the impugned OM, at the very first paragraph of 170.
No, see, Bhagwan Patel judgment now has to be read with IV.
IV, my lord. IV.
Right.
Yes,
So
my lord.
Bhagwan Patel judgment, whatever was stated,
Yes.
will have to be read
Yes.
with the division bench judgment, because ultimately that will prevail.
Correctly, my lord.
And it has been very clear that whatever has not been stated in the division bench judgment, if the Bhagwan Patel judgment runs contrary, that is deemed to be overruled.
So, my lord, if I may take my lord, at para 37 of IV, I will just read, my lord, just hardly three to four lines.
Para?
Para 37 of IV. But here it says that the 2002 OM has not been withdrawn. That means that the consequential seniority granted to these persons of the reserve category candidates still hold. At para 37, page number 30.
Wait, just a minute.
Writ appeal 46, that is IV.
Yes. 36. 36.
37.
37.
At page number 30.
Yes. Conjoined reading.
Accordingly, it would have to be concluded that a conjoint reading of clause 1.11 and clause 14 of the office memorandum dated 29/12
has not been withdrawn.
That has not been. Similar to consequential seniority,
we agree. Perhaps we may agree with your submission that yes, position as it was in 2002 remains, unless it is withdrawn. We are asking you from the standpoint of the principle, whether that principle has been done away with completely.
Yes, Milord, in my respectful and limited knowledge of understanding, Milord, there is a judgment of the Supreme Court called S. Paneer Silva, Milord, which has been referred by the other side. One of the paragraph which has been cited by them, it says, in the absence of rule, catch-up principle will follow. So, Milord, what I understand from there, if there is consequential seniority, catch-up cannot go. Milord, two rules cannot go at the same time. One is for the benefit of the
consequential seniority would mean that notwithstanding unreserved category getting promoted subsequently in the higher post later than the reserved category candidate.
No, that was only in the respect of that impugned clause where it says meritorious candidates would be barred if they have earlier gained consequential seniority.
We are on this interpretation of notification, office memorandum, para 37.
Para 37. You know, that 2014 OM, you know, that was one which laid down the guidelines for implementation of the RK Sabharwal's roster position, how the roster would operate. But if I may take my lord to that OM also, my lord, it lays out the guidelines. And my lord, it was to give effect to the Act of 2012, the 1978 Act, my lord, that is still in existence. Until and unless, my lord, that is.
Let us see the Act.
Yes, my lord, it's already there in the compilation.
It is there.
Yes, my lord, we have annexed this amendment. 49, my lord. 49 of this writ petition. Page number 49.
49 of the writ petition.
Yes, my lord.
Okay.
The act basically was an amendment pursuant to RK Sabharwal. The operative part is at page 50, section 5A, 51. Lordship will come to 5A. In the Principal Act, after section 5, the following section 5A shall be inserted. 5A, manner and procedure of giving effect of reservation. The reservation for the members of the scheduled caste and the scheduled tribe in services or posts in an establishment shall be given effect to in the following manner. Namely, number 1, a post-based roster register will be maintained to give effect to the reservation of vacancies for scheduled caste and scheduled tribe. Such rosters shall be based on model roster as per Schedule 1 and 2 appended to the Act and shall be adopted for the purpose by each establishment in such manner that the prescribed percentage of reservation is maintained in each cadre. Number two, each appointing authority shall prepare and notify the roster based on the principle laid down in this act and maintain a roster register in a manner containing such members of the points as are equivalent to the number of posts in a cadre. In case of any increase or decrease in the cadre strength, the roster shall accordingly be expanded or contracted. So in the act itself, the concept of cadre is specified. Number three, the roster is to be operated on a principle of replacement and not a running account. In other words, the points at which reservation for different categories applies are fixed as per the rosters and vacancies caused by retirement, etc., of persons occupying those points shall be filled up by appointment of persons of the respective category. The reason, Lordship, I just want to specify so that our prescribed percentage is always maintained, 22% for the reserve and 78% for the general. 4, separate rosters are to be maintained for giving effect to reservation in direct recruitment and promotion. Number 5, cadres for the purpose of rosters shall maintain, cadres for the purpose of a roster shall mean a particular grade and shall comprise the number of posts to be filled up by a particular mode of recruitment in terms of the applicable recruitment rules. Thus, in a cadre of say 100 posts where the recruitment rules prescribe a ratio of 50:50 for direct recruitment or promotion, 2 rosters, 1 for direct recruitment and 1 for promotion when reservation in promotion applies, each comprising 50 points shall be drawn up on the lines of respective rosters. Number 6, since reservation does not apply to transfer on deputation or transfer, where the recruitment rules prescribe a percentage of posts to be filled up by this method, such posts shall be excluded while preparing the roster. 7, appointments of candidates belonging to the scheduled caste and scheduled tribe, which were made on merit and not due to reservation, are not to be counted towards reservation so far as the direct recruitment is concerned. In other words, they are to be treated as general category appointments. 8, for initial adoption of the post-based roster, the existing backlog vacancy in a cadre where the prescribed percentage of reservation for the scheduled caste and scheduled tribes has not been achieved as per post-based roster prepared under the Amendment Act shall be considered as vacancies released by recruitment, resignation, promotion of the person belonging to the said reserve category, and the same are to be filled up by direct recruitment or by promotion of eligible persons from the respective categories by special drive so that the prescribed percentage of reservation is maintained. Next, before making an appointment by direct recruitment, the appointing authority shall ascertain by consulting the roster register maintained by each department whether the post is reserved or unreserved, and if unreserved, for whom it is so reserved. Immediately after the appointment is made, the particulars thereof shall be entered in the roster register and signed by the appointing authority. In the absence of a qualified SC/ST, as the case may be in a particular year, the vacancies shall be carried forward and filled up in the next year. Next,
Yes.
every establishment shall prepare and notify the roster for such cadre, each cadre equivalent to the number of posts with the concurrence of the personnel department and the WPTBC department. Next, the roster shall be maintained separately for permanent and temporary posts. Next, a vacancy caused due to any reason whatsoever, except termination of service during the probation, shall be treated as fresh vacancy. And last, a candidate who claims to be a member of the scheduled caste or scheduled tribe shall support his candidature by a certificate from the DC subdivisional or from any other authority as may prescribed by the rules made therein. Well, immediately after the coming of the act, the amendment, the Assam government, Lordship, immediately brought in the guidelines of 2014 at page 58, because unless and until the guidelines are there, how will the government prepare? And
We'll have to take a break.
yes,
Come back at 2.
29th of January, December 2014, which was brought in pursuant to the R.K. Sabharwal's case and pursuant to the amendment in Assam. In Assam, after 13 years, was the amendment of 12 was brought in. Implementation of
Before that,
yes,
from page 52,
yes,
what would be your argument
yes,
or submissions in
yes,
respect of the amendments brought
yes. My
vis-a-vis the effect?
yes, my submission is that the entire case is now hinging on one stand taken by the state of Assam and the private respondent, that since the 2002 OM was overruled by the OM of 2014, their contention, there could not have been any consequential seniority given to you. That was their case. In 2 forums now, I'll be showing that both the learned single judge and the division bench categorically rejected that argument, stating that the 2014 OM is on an issue of post-based reservation and the guidelines. It has nothing to do with consequential seniority pursuant to the 85th Amendment. And the 2002 OM, the power flows from Section 5 of the 78 Act and the amendment of 2012. This has been a categorical finding of learned single judge, because the power of roster starts in Section 5, and roster envisages accelerated promotion and consequential seniority, which has been upheld in Nagraj. There is no second thought on that. So, in fact, if your lordship, before I come to 14, I'll just take your lordship to a very important...
Consequential seniority, where do you find it from these amendments?
My lord,
5A.
My lord, consequential seniority is implicit in Section 5, because consequential seniority will be given pursuant to the cadre rules, the rules.
Yes.
And in fact, your lordship, I'm taking your lordship again to page 103.
1 minute.
104, because this has been the entire argument of the government as well as the private respondent. Lordship will come to the operative part at page 105. Roman 10, because this is the power which they say they have that power to give it or not to give it. I'll read it. 9, Roman 9, Article 6.
You're referring to?
Page 105 of the Bhagwan Pata's judgment. Writ petition also at page 105.
Okay,
writ petition, I have annexed it.
Yes.
Your lordship will come to Roman 9. Article 16.4a and 16.4b being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide reservation in promotion. This ending part is important. However, while implementing, adopting, changing, the Assam government has gone for a change. Such policy, due process of law needs to be followed, including the dicta of Nagraj and Jarnel. So, the learned single judge never said that you have been given the blanket power to do away with it, because ultimately you have to do it whether, provided it is compliant Nagraj. And what is Nagraj? It upheld 16.4a, giving accelerated promotion and consequential seniority. There is no second thought of it. The constitutional validity was upheld.
It upheld as an enabling provision.
Enabling, but now, my lord, the argument that it's an enabling provision, it becomes an enforceable right once the Assam government brought in the 2002.
That is 2002 memorandum.
Memorandum, because the government can go it by memorandum as well as by rule. Indra Swani is very clear. So once it is, the question of enabling doesn't come.
So essentially what you're saying is 5A section which was amended.
Yes.
Does not contain that. 5A section in itself does not contain consequential seniority. Rather, it was brought in by
the
OM,
2002 OM.
2002
Yes,
OM.
because what has happened, the judgment which was referred by my learned friend he makes his argument, countering my argument that in the Pena Silvam's case, the consequential seniority was not automatic. Well, I do agree. In Tamil Nadu, it was not automatic because the rules never provided. In fact, the judgment, when I go to the judgment, I'll show in the absence of rules, the catch-up principle comes in. In Assam, there is the presence of rule. And what is that rule? The 2002 OM, which has not been interfered neither by the single judge or the division bench. Because in paragraph 39 of the Bhagwan I.V. Guha's case, the learned single judge took up the same argument of the council, state and private, rejected it, saying that it is not withdrawn. If it is not withdrawn, from where you got the power in 2022 to bring in and presently deprive us of our due proportion? That is our case. So basically, that liberty is not a license. It is a liberty. And the Assam government, there is a judgment of Honorable Justice Chalamishar on a very interesting issue, where the Supreme Court says that if it is an enforceable right, if it is an enabling provision and it becomes an enforceable right, once you enable it, then the reserve have a right to seek justice before a court of law. You cannot prevent it. In fact, Lordship, this argument which has been advanced, I've gone through now, lots of blogs are written, that it's an enabling provision, you can give, you cannot give, is absolutely fallacious for the simple reason now, reservation is a mode of achieving equality that has been cleared by the Supreme Court from the Thomas case of 74. Earlier, it was from 1950 to 76, it was an exception to Article 16(1). A new law has come in. It's a part of equality because you have to bring them to the mainstream, give them the additional push-up in the form of protective discrimination. You have to give them some benefit and then allow them to compete. And then they do the national good. The larger public interest is protected. So this was the reason why from Indra Swani down to R.K. Sabharwal, merit was always an issue. A lot of cases happened in India on reservation, and this has been settled by the Supreme Court, ending with the Saurav Yadav's case, where Honorable Justice H. Roy is our part, will place it, that you cannot deprive them when they go on merit. You cannot put fetters. And my case, I proved from Bhagwan Patar that the Assam government bringing in clause 4 was a fetter to prevent us from getting merit. The Assam government bringing in the same provision in the OM of 2023, again brought in, and they brazenly brought in the catch-up principle. And towards the end, last time I have shown.
You see the problem.
Yes.
What is troubling the court?
Yes.
The judgments galore. You take up a entry grade post, entry into the service. Let us say this is engineering, so it is
Or assistant
engineer. So assistant engineer, you will have a direct recruit.
Yes.
There will be reservations. Whoever gets into, gets into. Next promotion is assistant executive engineer.
Yes.
Now, while you select the promotion, you will have to find out what are the rooster points in assistant executive engineer. Your service rules say 3 times or 4 times the vacancy is the zone of consideration. While doing so, you find that some points, say SC or ST, these candidates do not fall into the zone of consideration. Now, by virtue of this reservation, by the fact that they're reserved category and those posts have been lying vacant or etc., the government can bring them into the zone of consideration, select them. They get promoted to the next higher post. However, in the entry post, the feeder category, there was a select list, seniority list. In that seniority list, they were down below some of the unreserved categories, candidates. Now, the moment you put them into the zone of consideration, give them, one argument could be that now this is the criteria for merit. What I'm trying to say is, notwithstanding they do not fall into the zone of consideration, assuming the DPC takes a decision, brings them into the zone of consideration, they get promotion. On the higher post, they have been placed higher than what they were in respect vis-a-vis the unreserved category in
Because the higher post merit is the rules. The rules are from
no, no,
a particular.
no, no. What I'm trying to tell you is, your argument is notwithstanding they being brought up, ultimately they faced a departmental promotion committee
Yes, at each level.
at each level.
Yes.
So that departmental promotion committee is the authority which determines the merit.
Yes.
And having been given the promotion,
In the
it cannot
cadre.
be said that it is not done on merit. Right? That is your argument.
No, it is not done on merit. My argument was the OM of clause 4 and this OM, the latest OM, they debarred us from competing on merit. They say you got it earlier, now you will not get. Where is the law? That is the
No. You're challenging this because of the argument that the moment you get selected by a DPC, you are considered to be in merit.
merit. Yes.
So once you are considered to be in merit and
Merit.
you are promoted,
Yes.
there's
you
no
are
question of
considered as a
giving.
reserve.
There's no question of somebody being given catch-up rule above you,
Question doesn't come.
and which has now been sought to be enforced by these memorandums.
Yes, because why? In fact, your lordship will see in the Nagras, your lordship has rightly asked a very pertinent question on the last day that kindly show the object of 85th Amendment. The object of 85th Amendment was that the Ajit Singh 1 and 2 and Nirpal Singh Chauhan, which the respondents are harping, they gave catch-up principle, and as a result, the reserve, the scheduled caste and scheduled tribe could not come up. They lost. It is at that point of time that the parliament thought that their protection of their right has to be, because ultimately they will never be adequately represented in service. Now, what has happened? I'll just give you an example. In the Prabir Kakoti's case, he was #1 secretary. He was out for commissioner to become a commissioner. For 25 years, he got his promotion. No challenge, no problem, no OM. Suddenly, the Assam government brings him down by the OM of 2000, takes him to 24. He loses his seniority. He loses his cadre seniority. And by a stroke of a pen, you take away retrospectively my hard-earned promotion and consequential seniority. And in fact, your lordship, this is for the first time we find out that the personnel department, I have been saying with documents, that they never made cadre in the Assam Civil Service, which is supposed to be a premier civil service of this big board of the executive. They don't have, they have a grade.
What is the criteria for promotion here?
There the promotion is same like the engineering. It is merit with due regard to seniority and cadre promotion. As you go in the cadre, your promotions seniorities are assigned. Very specific. And in fact, I have shown an instance.
Have you enclosed any of the DPC's resolutions
Yes,
or
in
minute?
all cases I have enclosed. In fact, on the last occasion I have given, I'll again furnish. In the secretarial service, the clerical service, there is a cadre known as the Assam Secretarial Service. There, they are following the cadre rules. Malay, can it be that you pick up a service, you give them cadre promotion, others you deprive them? Well, this is a government's notification. The lordship will find.
Can you take us to at least one of the minutes by which?
Yes, Mala, minutes are very simple. I'll come to 665. I'll take your lordship. They say because of the OM of 2003, we are doing it. Well, this is the secretarials. There your lordship will find that they have cadres. And there is no question of a column where date of initial entry is brought in. Because what happens, once you bring in initial service cadre, column, you can bring in the catch-up principle through the back door.
No, there is a column date of entry in government service.
Yes. Lordship will take up the page 363.
No, we are referring to this document which you given us.
Yes.
363 of?
My
363
Lanthasa, 363 WPC. There I have shown that Mr.
Page number?
Yes. Your lordship, page 115.
115.
Your lordship will come to 15, serial 15, Radhesam Lanthasa.
Yes.
First is date of birth. The next column is date of appointment in the department. Next is date of joining a superintendent engineer. Malad, this is very important. Your Lordship will find that Radhesam Langthasa comes to the cadre of super in the year 2018. And then your Lordship will come to page 117, which is the final gradation list. Now, what is the loss I will show? Lordship will come to page 118, serial 17, Radheshwar Langthasa. The column remains same. They add up the third line, which is APSC list. Lordship will find I come to the cadre of superintendent engineer in 2018 by a selection process. The persons from 1 to 15, they are general. They come to the cadre in 20 and 22. Well, like 2-3 years after I am in the cadre and I now go down, no reason, only one reason, catch-up principle we have brought in. Well, what more ex facie violation, prima facie violation is required? I lose my seniority. And all along I have got my selection through a merit process, because from executive engineer onwards, it is a merit-based selection.
No, for the promotion, this is in which post?
For the post of additional chief engineer, because I lost.
No, this page 117 is the gradation list of superintendent.
Yeah, feeder grade is always superintendent engineer.
Now, in this post, how the selections were made? Is there any, is the minutes available?
Yes.
Must be available.
665, we had, they didn't give us the minute when we moved the course towards the end to the judicial.
Okay, it will be available with the government.
Yes.
Must be
They
available.
don't say anything. They say only one thing. In view of the 2023 OM, your seniority is now this. Means I go lost and your selection is done. You are gone 6. You will you don't come within the zone. Whereas my position was item serial 2 and I go down 17 and vacancy is 7. This is how I lose.
All right.
Then Lordship, Lordship will come to the part which I was referring to. I just want to take the Lordship to page 100 and page 60, 363, page 60, page 50.
60.
Yes. Before that, page 58, the office memorandum.
Yes.
I want to read. This is an office memorandum of 29 December 2012. Implementation of post base. Consequent upon the amendment in the 78 Act and the acceptance of the recommendation of the one-man commission of Sonowal regarding acquiring quantifiable data and backwardness backwardness is not required now. There any inadequacy and impact of efficiency. The following guidelines has been prescribed in order to implement the post-based reservation in matters of reservation of post for SC, ST in direct recruitment and promotion. Your Lordship will come to page 60. Different set of guidelines. Your Lordship will find that the guidelines are basically a reiteration of the provision in the Act. They are now bringing in the form of guidelines. Your Lordship will come to SC, ST candidates appointed on merit, because my right flows from this portion of the guidelines. 3.1. In case of direct recruitment and promotion, Your Lordship, can I read?
Yes, yes.
SC, STP and STH who have been appointed on their merit and owing not to a reservation should not be shown against reserve quota. They are adjusted against unreserved quota. This the Assam government is not doing. They are already only adjusting me against reserve quota. They are silent on the merit part. Then 3.2, if a unreserved vacancy arises in a cadre and there is SC, STP and STH candidate within the common zone of consideration in the feeder cadre, such candidate cannot be denied promotion on the plea that the post is not reserved. Means what? You cannot.
What is the meaning of appointed on merit and not owing to their representation? Reservation. What is the meaning of that?
Means,
3.1.
Means what happened? Accelerated promotion, how I go, that has been explained by
No, we want to know. We want to know what is the meaning of 3.1.
3.1. In case of direct and promotion, SC, STH who has been appointed on their merit and ought not to a reservation. Means when they
They are
go,
the creamy layer,
no, there is no creamy layer for SC, ST. Well, creamy layer is only for the OBC.
OBCs.
Supreme Court, Indus 1 here said they are a class apart. Unless Parliament makes a law in India, till now they have not made it. 75 years have passed. Now, what they say that once you get it on merit, means how you get it on merit, as you go up the ladder, you always compete on merit. So when you compete on merit, there cannot be any fetter. In fact, my entire case was harping on Bhagwan.
So that's what we are trying to, we are asking you.
Yes.
How do you interpret clause 3.1 insofar as the meaning ascribed to these appointed on their merit and owing not to reservation? Anyone, any
Well,
reserve
it's-
category, any,
yes.
according to you, any reserve category who gets appointed on merit.
No, not any reserve category. Any reserve category who competes through a selection process
Right.
for the said post. If he
Is there
gets on
any,
that,
is there any other mode of appointing any reserve category, but subject to the provisions of the service rules?
arising why the reserve can go on the unreserved post, a peculiar situation, but the unreserved cannot come on reserve post. In Assam, what they have done, they have allowed us and said that you will be given prescribed percentage. In fact, paragraph 1 of all the OM starts with the reservation in promotion will be complied. Your prescribed percentage will be followed. But we will take away your accelerated seniority, means we will take away your earlier earned seniority under the rules. Can they do it? Lordship will come to 3.2. It makes it more clear. If any unreserved vacancy arises in a cadre and there is SC, STP and STH candidates within the common zone of consideration in the feeder cadre, such candidate cannot be denied promotion on the plea that the post is not reserved. Such candidate shall be considered for promotion along with candidates treating him as if he belongs to the general category. In case he is selected, he shall be appointed to the post and shall be adjusted against the unreserved post. Has the personnel department doing it? Since 2016, they brought in this OM to deny us. This was
Please come again, 3.2.
I'll again read. If an unreserved vacancy arises in a cadre, and there is SC, STP and STH candidate within the common zone of consideration in the feeder cadre, such candidates cannot be denied promotion on the plea that the post is not reserved. Such candidate shall be considered for promotion along with the other candidates treating him as if he belongs to the general. In case he is selected, he shall be appointed to the post and shall be adjusted against the unreserved.
This is over and above the reserve category post.
Yes, and this paragraph 3.2 and the other paragraph, Mala, I'll show it goes counter to the OM of 2003, because the OM of 2003, 23 clearly says that you will be considered provided you did not get it by way of accelerated promotion. That is the fetter. And if the OM, the acts of 78, 12 and the guidelines of 14 has a specific provision giving benefit on merit to the reserve, what was the necessity of the Assam government to come with an OM of 16 and 2023 to deprive us of our consequential seniority? That is my, in fact, this is the trust. The third, 3.3. Similarly, SC, STP and STH candidates appointed on their own merit by direct recruitment or promotion and adjusted against unreserved point, I mean, this is important, Lordship, shall continue to retain their status as SC, STP and STH and shall be eligible to get benefit of reservation in the next or future promotion, if any. Well, absolutely, there is no fetter. If there is no fetter, who has given you the right to override act given under the act and basically depriving us of. In fact, Lordship will find that now I'll take Lordship, now I'll take Lordship. This was the case, the R.K. Sabharwal case, which was referred in the Journal Singh case also, and where in paragraph 4 of Sabharwal, it makes a clear categorical. In the compilation, your Lordship can, your Lordship takes up the R.K. Sabharwal, FAP is first. 22 of the compilation. In fact, this OM of 14 was absolutely R.K. Sabharwal compliant. A Supreme Court compliant OM was destroyed by the Personnel Department of the state of Assam, and they took us that benefit from us.
Yes.
Lordship will find, in fact, this find reference in the Journal Singh case also. Paragraph 4. When a percentage of reservation is fixed, can I read? Page 27 of my compilation.
Yes.
When a percentage of reservation is fixed, in respect of a particular cadre, and the roster indicates the reserve point, it has to be taken that the posts shown at the reserve points are to be filled up from amongst the members of the reserve category, and the candidates belonging to the general category are not entitled to be considered for the reserve post. Exclusive power given. On the other hand, the reserve candidate can compete for non-reserve posts. In Assam from 2016 till now, I cannot compete. You have already blocked me. On the other hand, the reserve category candidates can compete for non-reserve posts. And in the event of their appointment to the said post, their numbers cannot be added and taken into consideration for working out the percentage of reservation. 16(4) of the Constitution permits the state government to make any provision for the reservation of appointment or post in favor of any backward class of citizen, which in the opinion of the state is not adequately represented in the service under the state. It is therefore incumbent on the state government to reach a conclusion that the backward classes for which the reserve is made is not adequately represented in the state service. While doing so, the state may take the total population of a particular backward class and its representation in the state services. When the state government, after doing the necessary exercise, makes the reservation and provides the extent of percentage of posts to be reserved for the said backward class, then the percentage has to be followed strictly. In my case, they have never followed. The prescribed percentage cannot be varied or changed simply because some of the members of the backward class has already been appointed, promoted against general posts. As mentioned above, the roster points which is reserved for the backward class has to be filled up by way of appointment, promotion of the members of the said class. No general category can be appointed against the slot in the roster which is reserved for the backward. The fact that considerable number of members of backward has been appointed, promoted against general posts in the state may be a relevant factor for the state government to review the question of continued reservation for that class. But so long as the instructions and the rules providing certain percentage of reservation for the backward classes are operative, the same has to be followed. Despite any number of appointees, promotees belonging to the backward classes against the general category post in the given percentage has to be provided. The given percentage has to be provided in addition. We therefore see no force in the first contention raised by the Learned Counsel and reject the same. Because they took up the plea that the general were affected. The court rejected it. In fact, this is the law till date. In journal, this was reiterated. It basically started in Nagraj. And in journal, in paragraph 36 onwards, it makes the same reiteration, paragraph 36, 37, 38. If I may read, Lordship. Well, it's in Journal Singh 2, Lordship wanted the citation, 2022 10 SCC 595. The copy has been given.
22.
Yes, Manu.
2022.
2022 10 SCC 595. We have given the copy.
Yes.
There in paragraph 26, in fact, journal seemed to happen because throughout the country, these issues started arising, and the reserve filed cases in the Supreme Court saying that their merit was denied to them, and only the prescribed percentage was given. As a result, they were denied. But in paragraph
Yes, paragraph.
Yes, paragraph 18, my lord.
18.
Yes, Lordship. 18, paragraph 18. This is the unit for collecting quantifiable data, because the unit has to be the cadre. There, again, this case is referred. Seniority of superintendent engineer in the irrigation department of the state of Punjab was the subject matter of writ petition under Article 32 of the Constitution. Can I read?
Yes, please.
In R.K. Sabharwal, the relevant instruction issued by the state of Punjab providing for 14% reservation for scheduled caste. 2 points came up for consideration before this court in the said judgment. The first being that in case more than 14% of the scheduled caste candidates are appointed, promoted in a cadre on their own merit, seniority, then the purpose of reservation having been achieved in the same cadre, the government instruction providing reservation would become inoperative. The second point on which the argument was heard is that roster cannot operate once the posts earmarked for the SC, ST and backward classes are filled. Any post falling vacant in a cadre thereafter is to be filled up from the category reserve or general due to retirement of which member the post fell vacant. The first point raised by general category candidate was rejected by the Supreme Court by holding that the reserve category candidates can compete for non-reserve posts, and in the event of their appointment to the said post, their numbers cannot be added and taken into consideration for working out the percentage of reservation. My lord, here I'll just point out that the Assam government has done the mischief of counting that. They say that we have given you the reservation prescribed percentage, you will not get on merit, because they have to bring in the catch-up principle through the back door. The relevant instruction contained in this
Yes.
The second point on which the argument was heard is that the roster cannot operate once the posts earmarked for the SC, ST are filled. Any post falling vacant in the cadre is to be filled from the category general or reserve due to the retirement of which the number of posts fell vacant. The first point raised by the general candidates were rejected by the court by holding that the reserve category candidates can compete for non-reserve posts, and in the event of their appointment to their post, their number cannot be added and taken into consideration for working out the percentage of reservation. The court was of the opinion that Article 16(4) of the Constitution of India enables the state government to make provisions for the reservation in favor of any backward class or citizen which in the opinion of the state is not adequately represented in service. The percentage of posts reserved for backward classes as prescribed by the state has to be strictly followed and cannot be varied or changed simply because some members of the backward class has already been appointed, promoted against the general seats. The second point relating to the implementation of the roster in the form of running account year to year, roster points were fixed in a lot of 100 posts. The court held that once 14% posts earmarked in the rosters are filled up, the result envisaged by the instruction is achieved. Thereafter, there is no justification for operating the roster. The court observed that the running account is to operate only till the quota provided by the instruction is reached, and not thereafter. The vacancy arising in the cadre after the initial posts are filled will have to be filled from amongst the category to which the posts belong to the roster. Nagraj, this court observed that the appropriate government has to apply the cadre strength as a unit in the operation of the roster in order to ascertain whether a given class or group is adequately represented in the service. Cadre strength as a unit always ensures the upper ceiling limit of 50% is not violated. Following the law laid down in R.K. Sabharwal, this court in M. Nagraj further held that the roster has to be post-specific and not vacancy-based. In Nagraj, this court held that it is open to the state to provide for reservation subject to limitation, but this is not required because this was not a. So my contention is that taking a cue of the amendment of 2012 and the OM of 2014, the Chief Secretary to the Government of Assam rightly files an affidavit in the year 2012 before the division bench saying that we will comply with letter and spirit of R.K. Sabharwal. After saying so, what has happened in 2006 is completely opposite. They have brought in a principle, virtually they have overridden the 2014 OM. In fact, your lordship, if I take your lordship to Ivy Guhai's judgment at paragraph 37, elaborate arguments was being made on a particular clause, two clauses of the OM of 2014. In paragraph 37 of IB Guhai's case, arguments by the state as well as by the private respondents that clause 1.1 and clause 14 of the office memorandum has basically overruled the OM of 2002. The court held, the division bench held in para 37. Accordingly, it would have to be concluded that a conjoined reading of clause 1.1, 1.11 and clause 14 of the office memorandum dated 29/12/2014 should mean that a consequential seniority that was otherwise meted by the office memorandum of 12/3 has not been withdrawn. Similarly, in the single bench's order also, the division bench never passed any order regarding the power flowing from section 5, where meritorious reserve cannot be deprived. Basically talking about clause 4 of R.K. Sabharwal. So after the division bench and the single bench holding in clear and categorical terms that the 2002 remains because the power flows from the 78 Act until and unless the 78 Act is withdrawn or due compliance of Nagraj in journalising undertaken by the state of Assam, who has given authority to the personnel department to completely abrogate the rights which we get under the constitution and the act. Well, that is the sum and substance of my case. Nothing better than legal malice. Well, legal malice is writ large. Well, it is violative of constitution and judicial decisions. Well, this OM expecie needs to be quashed. And our seniority in terms of the cadre rules be restored and we be given our entitlements. In fact, if I take your lordship to the enabling part, because enabling is an argument which has been advanced by my opposition since 2016. My lord, your lordship will take up compilation page 81. This is a judgment regarding a reservation matter only. And paragraph 24, page 80 of the compilation. This was a case from the Supreme Court in 2016.
Page number?
Page number 80, paragraph 24, down below. In the first instance, we make it clear that there is no dispute about the constitutional position envisaged in, can I read?
Yes, yes.
In 15 and 16, insofar as this provision empowered the state to take affirmative action in favor of SC/ST candidates.
You are reading Paresh Chandra Dekha.
No, but I'm reading.
What is that?
8080, Lordship.
80 is what judgment?
My lord, I'll just page 70 to 84, page serial 9, Chairman Managing Director.
Okay.
Central Bank. Page 24.
Okay.
Sorry, paragraph 24. In the first instance,
Yes.
We make it clear, well, I'll give this Supreme Court citation for 2016 1 SEC.
Yes, it's here.
It's there.
It is here. Yes.
In the first instance, we make it clear that there is no dispute about the constitutional provision envisaged in 15 and 16, insofar as these provisions empower the state to make affirmative action in favor of SC and ST categories by making reservation for them in the employment in the union or the state, or for that matter, public sector authorities, which are treated as state under Article 12 of the Constitution. The laudable objects underlying this provision is also to keep in mind, while undertaking any exercise pertaining to the issue touching upon reservation of such SC/ST employees. Further, such a reservation can not only be made at the entry level, but it is permissible in the matters of promotion as well. At the same time, it is also to be borne in mind that Clause 4 and Clause 4A of the Article 16 of the Constitution are only enabling provision which permits the state to make provision for reservation of those categories of persons. Insofar as making of provision for reservation in promotion to any class or classes of post in concern, such a provision can be made in favor of SC/ST category employees if, in the opinion of the state, they are not adequately represented in service under the state. Thus, no doubt power lies with the state to make a provision, but at the same time, courts cannot issue any mandamus to the state to necessarily make such provision. Correctly so. It is for the state to act in a given situation and take affirmative action. Of course, this is important. Whenever there exists such a provision of reservation in matters of recruitment or promotion, in Assam we have, it would bestow enforceable right in favor of the persons belonging to SC/ST category on failure on the part of the authority to reserve the post while making such selection, promotion. The beneficiaries of these provisions can approach the court to get their rights enforced. What is to be highlighted is the existence of provision of reservation in the matter of selection or promotion, as the case may be, is the sine qua non for seeking mandamus, and it is only when such a provision is made by a state, a right shall accrue in favor and not otherwise. My enforceable right flows from it. So the argument of the respondent that it is enabling provision, what right you have got, we can make it or we can debar you, is absolutely false. It's absolutely wrong. Then your lordship will find in the Paresh Dekka's case, which also started with, I was there in that case, that was also a fight for the consequential seniority. At page 61 of the compilation, lordship.
Yes.
It was at paragraph 11, the categorical submission of the additional advocate general at that point of time. Mr. Dolo
Yes, please.
further submits that Article 16(4) of the Constitution of India was amended by the 85th Amendment with effect from 17/6/95, by which government employees in the reserve category on promotion as per the roster and rules of reservation is entitled to consequential seniority. Accordingly, the state government issued the said OM on 12/3/2002 to give effect to the enabling provision of 16(4)(a). My lord, the state government will take stands at different forums at different point. Before the division bench, the chief secretary will say, we'll comply with R.K. Sabharwal. Before the division single bench, the additional advocate general at that point of time says it's an enabling provision. We have enforced it. It is enabled. We'll give them the benefit. Today they will say we will not give them the benefit because we have the option of giving you, not giving. Giving you, not giving you ends with a rider. It has to be Nagraj and journal compliant. Does the government of Assam have that power and authority to overcome Nagraj and journal and give that benefit to the general by depriving us our entitlements under the law? Can they do it? They can't do it. And the fact that in the Bhogeshwar Saikia's case, my lord, I won't take your lordship. I'll just give the citation at serial 7. This issue came up in the year 2010. And this OM of 2002 was challenged by both the general and the reserve, and it was held to be sustainable in law. So 2002 has been upheld in the Bhogeshwar Saikia's case. And in fact, it takes its judgment, Bhogeshwar Saikia's case takes a cue from a 9-member bench of the Supreme Court in Indra Swani in paragraph 859. That an executive order by the government under 16(4)(a) is enforceable the moment it is issued.
Yes.
So till now, the state of Assam could not have withdrawn 2002 by an office memorandum. In fact, when I go to the 2023 OM, I'll find what you will find down below. Well, you do a mischief, but with some authority, by complying with the constitution. They say that the 2016 OM is withdrawn. I do understand you are bringing in a new OM, basically the same OM in a new name, shape, and you add up the 2002 is also withdrawn, superseded. Means the 78 amendment, the amendments and the 78 Act.
16 did not say it was over. OM 16.
Yes.
Did not mention about.
No, it never said. Here they went a step further. The reason was the Bhagwan Pata judgment was staring on their face. So they did not want to comply with the Bhagwan Pata judgment for 1.5 years. They waited, and in the month of January of 2023, they came up with this OM. As a result, we could not get any benefit of that. We had to again approach this court.
Very well.
And secondly, and the single judge and the division bench has clearly stated that the arguments of the OM of 2002 being withdrawn because of the OM of 16 and 2014 is negated. So after that stamp of approval, the state of Assam, if they wanted a change, they could have gone to the Supreme Court. They never went. In fact, they never went. The private parties only had gone before the division bench in IV Gohai's. State kept silent. And state took the plea, but the arguments
the single bench and division bench held that the 16 memorandum did not supersede the 2002.
Yes, correct.
But there was no finding subject to correction. So was there any finding that 2002 memorandum being in place and having sourced from this act?
Section
5A.
Yes.
There is no question of superseding. That finding is not there.
No, in fact, the division bench also did not want counter it because the division bench never went on it because it felt.
No. The question is perhaps subject to understanding. Correction. The issue before the courts was whether, in view of 2002, can you issue 16 notification?
Yes.
And that was upheld, saying that no, 2002 is already there. 16 is just clarification of 2002 or 2014 notification. That was held.
And it was held that the arbitrary clause of denying the benefit on merit could not have been given because the judgment towards the end says meritorious reserve candidate. It talked about paragraph 4 of R.K. Sabharwal. In fact, if I may read your lordship again, the judgment. It was very specific, in fact. Yes, ma'am. Bhagwan Pata. If I may read page 103.
103 of the compilation.
Yeah, I'll just take up one paragraph, lordship. Page 103. This is the elaborate finding was given by the single bench also, and in IV Gohai, paragraph 39. Lordship will come to page 100.
Clause 4 is violative of section 5.
Yes, but above that I want to read Roman 10, the earlier. In the case in hand, can I read?
Yes.
The two OMs, because the argument was hinging on that. The two OMs of 12/3/2002 and 3/8/16 are incompatible for the reason that the OM dated 12/3/2002 is an executive order by way of which the benefit of consequential seniority was made available to the reserved category candidates and was issued subsequent to the incorporation of 1640 of the Constitution of India. Whereas the Office Memorandum of 3816 lays down the procedure for collection of quantifiable data, etc., while implementing the provision of Section 5 and 5A of the Act of 78. That being the position, this is important. This court unhesitatingly holds that the policy of providing reservation and promotion with consequential seniority is holding the field. Therefore, the arguments of K. N. Chaudhary, learned senior counsel, that by way of the Memorandum of 16 has been issued in supersession of the OMF 2002 is not finding favor from this court. And in the division bench, the argument of 2014 was taken that this has superseded 2002. That was negated in paragraph 39 of the Ivy Guhai's case, stating that it holds the field, it is not withdrawn. So all intents and purpose, the law laid down by two forums of this court is 2002 is in operation. You cannot take away the benefit of consequential seniority. And now with this OM, you have virtually taken away, abrogated it. You have brought in, explicitly you have brought in. Mala, they have never brought.
Because of the liberty granted.
Yes, and the liberty granted by violating Nagraj and Journal, because it specifically say it has to be Nagraj and Journal compliant. Today in Journal 2, when the Supreme Court has categorically said that if you take the entire service into consideration, not a single reserve will ever get promotion in India. They will always lie below because you have, or you'll take a march, the cadre promotion will go. So they say that you cannot group it, it has to be cadre wise. What more is required? The Assam government through the OM has brought upon, I'll say it is bordering on irrationality, and irrationality is one of the grounds of judicial review. Three grounds are there basically: illegality, irrationality, and procedural impropriety. Irrationality. What they did, A category, you will not get consequential seniority. B, C, D, you will get it. Means down below you'll get up, when you go up, you will be thrown out. And towards the end, they say that it is in supersession of the OM of 2016 and 2002.
What are these group A, B, C categories?
To my knowledge, the Assam government has not specified, but my knowledge is that it is based on grades. Grades are always referable to scales, means scales, means
Scale of pay.
Yes, scale of pay. So higher post.
Group A.
Yes. In fact, my clients are all from a group A post. Engineers and civil service, everyone is in there. Okay. So this is my submission. Well, in view of that, and the judgment which they have been referring, I could counter all these judgments. They refer to Mukesh Kumar. Mukesh Kumar is on a different point, whether mandamus can be issued. I agree with Mr. Chaudhary that you cannot issue mandamus to direct the government to make reservation. But when it is there, it is an enforceable. In Panna Silvam, both my learned friend, Mr. Mojumdar has also referred to that Panna Silvam talks about that it is not automatic. It is not automatic. Consequential seniority is not automatic. So how you will get it? You will not give it. Will not give it. Will give you the benefit of promotion. No. There, the entire case was whether there was a policy of reservation or not. In the Tamil Nadu Civil Engineering Service, they did not have that rule. Para 36 clearly says.
It's not a part of your compilation.
Yes. So there, in the absence of rule, catch-up comes in Assam. There is no question of absence. There is presence of rules reiterated by two forums, both by the single bench and the division bench. In the absence of rules, policy decision taken in the form of rules framed by the state of Tamil Nadu regarding Tamil Nadu Higher Engineering Service, accelerated promotion given to the respondent following rule of reservation will not give them consequential seniority. They will not get it because there is no rule. In Assam, there is a rule. Then what is the form, what is the point of having a rule when you brought this rule of 2002, you make a specific statement that the catch-up principle is withdrawn as if it never existed. From 2002, who has given the personnel department now authority in 2023 to come with a OM stating catch-up rule we are bringing in? Well, we cannot take public service to that level that in defiance of logic, they will do whatever they want. There is still semblance of rule of law in this country. The government has to follow with the rule of law, comply with judicial decisions. Judicial decision envisages a finality. And finality is the fact that the Assam government did not care to go to the Supreme Court. The law laid down by the single bench and the division bench has to be complied in letter and spirit. And all promotion given to the respondent pursuant to challenges being made needs to be quashed, and we should be restored, given our seniority back, and all gradation lists need to be redone. Because unless and until the gradation list is redone, the cadre benefits cannot be given, and the rules envisaged us. We get it on the rules. So by summing up, the fact that two grounds, that the 16(4)(a) being an enabling provision, the Assam government's 2002 holding the field, the single judge reiterating the same position, the division bench reiterating the same position, the laws of the country reiterating the same position. There is the rules of the department envisage a cadre-based promotion. The OM of 2023 needs to be struck down as violative of constitutional provision. Article 16(4)(a), Article 15, discrimination, Article 14, equality, Article 16, equality in matters of public employment. So, in fact, I am referring to a judgment where this sort of OMs were being challenged in the Supreme Court from 96 by the Reserve. It's a brilliant judgment by Ramaswamy, page 85, Lordship. 1997, 1 SCC 701. But there also, the bureaucracy took the leadership in bringing out OMs to deprive the SC/ST community. Supreme Court struck it down. Well, it's a very elaborate. And in fact, it quoted a constitutional provision that public 261, Article 261, public records, decisions by judicial forums have to be given respect by bureaucracy. It talks about article, it's a very brilliant judgment, 261, same provision. There also benefits were brought in to deprive the SC/ST community.
Paragraphs?
The paragraphs,
Paragraphs.
operative. I'll just go through the paragraph. Paragraph will be paragraph 23, where detailed bureaucratic style of function, how, and page 24, Lordship, that how government policy has to be given shape to, and para 24, if I may read, Lordship, can I?
24?
Yes, 98.
24?
Yes, para 24.
Yes.
Some treatise written by The Nature of Destiny of Man in New York, Charles Sons. Bureaucracy therefore shares this responsibility that it takes in its forward trust to effectuate the constitutional philosophy and public justice. Administrative responsibility lies in giving shape and content not only to the policy laid down in the Constitution and by the executive, but also applies to given facts of case. In this case, on the facts, the executive bureaucracy has forfeited the faith and credit according to them by the Constitution and betrayed a public faith in honest and dispassionate decision-making process and in applying the given set of standards of executive orders in giving promotion to different classes of officers in diametrically opposite way, frustrating constitutional objective to promote socio-economic justice and equality of opportunity of promotion to officers of the association. Well, here also the reserves were denied their promotion. That office memorandum story is there since it has been a long fight. In paragraph 25, it is a settled position of law that the Constitution has given the benefit of reservation, and having adopted the policy by the government, the policy should strictly be adhered to, and it should not be made a farce and introducing at the whims of the officers their own criteria contrary to general principle. It was directed by the court in UP versus Standon that the rule of reservation is applied and candidates were selected according to seniority vis-a-vis the general would be accordance with the rosters maintained by the state government. The same was reiterated in RK Tandon. Well, there also the rosters. Yet another problem that was brought in our notice is that while preparing their inter-C seniority and fitment, the government was not strictly following the rule of roster and reserve for SC/ST and their placement on the respective vacancy earmarked for them in the roster. It would be obvious that when the government makes appointment through administrative instructions and statutory rules, the appointed candidates must be in order of their merit and roster. Well, the government should follow the rule of reservation and make as per roster point. The procedure is also prescribed in the ad hoc rules. Therefore, even appointment from the list of such and such and among those retired from service or have the benefits of the court order or non-selectors, the inter-C seniority could accordingly be determined as per the laws of reservation and roster. Even among non-selected, they were appointed under ad hoc rules and seniority under rules, therefore determined that some principles should be followed. These roster points should be worked out and appointment made accordingly. There shall be a direction. Well, this is as regards they were denied the benefit of an office memorandum. My lord, the affidavit of the state government, my lord, I'll just take your lordship to the affidavit filed in 363 by Sri Povitra Khan. He is the secretary to the personnel department. My lord, if we take the affidavit of the secretary, basically he has supported my case. My lord, your lordship will come to the affidavit.
Yes, page number.
My lord, page number. This is an affidavit filed by respondent number
3.
Respondent
6. Povitra Khan.
Yes.
Yes. Okay.
Yes, my lord.
Paragraph.
Para 7, lordship will come.
Para 7.
That the deponent begs to state. Can you read?
Yes.
In paragraph 47 of the judgment of Jarnail and Lakshman Singh Narayan, it has been observed, the state should justify reservation in promotion with respect to the cadre on which promotion is made, taking into account the data pertaining to a group which would be an amalgamation of certain cadre in a service, would not give the correct picture of the inadequacy of representation of SC/SC in a cadre in relation to which reservation or promotion is sought to be made. Rosters are prepared cadre-wise and group-wise. Very good. They themselves say. Sampling method, which was adopted by the Ratna Prabha committee, might be statistical formula appropriate for collection of data. However, for the purpose of collection of data to access representation of SC and ST for the purpose of providing reservation in promotion, cadre, which is a part of a group, is the unit and a data has to be collected with respect in each cadre. Therefore, we hold that a conclusion of the court in BK Pavitra 2 approving the collection on the data on the basis of groups and not cadre is contrary to the law laid down in Nagraj and Jadel. So basically his own submission that it is the cadre which has to be followed, not groups. Well, it is, I will call it laughable that the secretary of the department of the personnel department who has brought this OM by violating every bit of constitution and the statutory provision himself says it must be cadre-wise. So basically, the Assam government has accepted my entire submission that the promotion has to be cadre-wise, not group-wise. And second, and in fact, if the catch-up principle, another submission which I make, if the catch-up principle is brought in, what will happen? We will go to pre-RK Sabarwal. The vacancy-based promotion will come in. In fact, this is the maneuver, this is the machination of the Assam government in the civil service, that as soon as vacancies come in, they start promoting people. They never make the cadre. And in fact, it is unheard of that 900 officers of the Assam Civil Service is having only one select group. That is great. Well, you don't know where you came, how you got your promotion in different cadre. Well, one group they make it, only they say that the post, commissioner, secretary, joint secretary, deputy secretary, no cadre. So virtually, in fact, positive direction should go from this court that the personnel department should start complying with the law, because I am told from my client, I get an information that for the past 25 years, they have never made any cadre rules. Means not cadre rules, they have never made any gradation list in terms of cadre. Whereas the civil service rules are very specific. But I'll give a copy of all the civil service rules and the engineering rules where they have never complied with it.
No, are you saying that in this service there has never been a gradation list?
No.
Qua the cadre?
No, that is the unique thing. Well, I'll show. There's in the Procedural case.
No. In this case, you refer to
No,
gradation
in this
list.
case, in the engineering service, they had a cadre. But with the bringing of the 16 and the 2023 AM, they are opening up another column, which is called the catch-up principle, the rate of initial entry. Unheard of. I have never heard of any.
Right.
But in the civil service, my lord, my case in Praveer Kagoti, that is 545, they don't have. Malad, they have simple, Lordship, I'll take your Lordship to Praveer Kagate's case 545. Well, this is an instance where it's an eye opener, I am saying. Yes, no. Item number 2. Item number 2. Item 73. Because the other cases are on similar line. We go up, we come down.
Yes.
Well, your Lordship will come to the gradation list of page 75.
75.
Lordship has seen serial 1, Praveer Kakati.
Yes.
The Lordship will find home district, Kamrup, date of birth, caste, grade, batch, means date of entry.
What is grade?
Well, a grade is, we don't know.
SEC, what is SEC?
Well, it's 2 SC. Every secretary. Well, a Lordship will find that secretary.
No, I don't think this is secretary.
No, sorry, it's not.
Below you'll find number 3 SEL, means perhaps selection
It's not
grade.
secretary.
Perhaps selection grade.
Yes, sorry, absolutely, selection grade. So that is, your Lordship will find there is no cadre column. And now from 1, I come down to 24 because they brought in the 2023 OM. But there is no cadre for the past 25 years. Well, in fact, the civil service somehow, they never went to court, possibly this Pandora's box never opened up. It is now that since these cases are coming up that this has, well, your Lordship will find that what are the government trying to do? How can they categorize us into a group and how can they find out in which grade, in which cadre we got our promotion? Is it that the one stroke of a pen, our entire cadre promotions are being set at naught?
This page 75 is it a part of 74?
Malan?
No. 75.
No. Malan, what has happened? 21 is I come to the cadre as secretary, Praveer Kagoti. Malan, what has happened in the gradation list? They upload it in the website. They never upload it in a normal procedure.
No, what I'm asking
Yes.
you is 75. What is is it a document prepared by the petitioner or?
Which one?
75?
No, my lord, this is the gradation list. We downloaded it from the website. This is how, and in a most untransparent way, non-transparent way, they make this gradation list. In fact, I am told we are never asked about that objection part. At least in the engineering department, that semblance of discipline is there. And in fact, lastly, I will conclude with the judgment last time I could not prepare, because of paucity of time, the journal seeing part, last part. Yes. Oh, Mr. In the compilation, Lordship,
Yes.
that is the most important part. Malat, I'll just read that paragraph 45 to 47 and I conclude my part.
Yes. 40.
For page 315.
No, you can say the paragraph.
Oh, sir,
45.
paragraph 45.
Yes. Yes.
Yes. Collection of data for determining the inadequacy of representation of SC/ST is a basic requirement for providing reservation in promotion, as laid down by this court in M. Nagraj. The unit for the purpose of collection of data is the cadre,
Sorry.
according to
Sorry, we are not with you. We'll have to- this is journal saying one copy of SCC has also been given.
Oh, yes, SCC I'm giving. Okay.
Yeah.
This, it is to 2022 10 SCC 595.
Yes.
The operative part is at page 66, Lordship. It starts from 64 to 69. Can I read?
You're reading from the printout of the judgment. 2210.
SCC.
Yes. 2210 SCC 595.
Yes, and para 64.
Para 60.
64 to 69 is the operative part, and where I will show that they could not have done it by class-wise, group-wise.
Yes.
That para 64, well, it's not required 65, Lordship will come to 66.
Yes.
The court in BK Pavitra 2 found that the challenge of the report on the group of data have been collected on the basis of group A, B, C, D as opposed to cadre to be without merit. The basis of thus conclusion, such said conclusion of the court was that there is no fixed meaning ascribed to the cadre in service jurisprudence. Further, this court held that collection of data on the inadequacy of representation in the services of the state, according to M. Nagraj. In addition, this court was also of the view that Article 16(4)(a) referred to inadequacy of representation in the services of the state. It was further declared that collection of data on the basis of groups does not exclude data pertaining to cadre as a group, includes post in all cadres in that group. 67. Collection of quantifiable data for determining the inadequacy of representation of SC and ST is a basic requirement for providing reservation in promotion as laid down by this court in M. Nagraj. The unit for the purpose of collection of data is a cadre, according to Nagraj and Journal. For the purpose of collection of quantifiable data for providing reservation in promotions, the entire service, this is important, cannot be taken to be a unit and treated as a cadre as already stated. The structure of service in the state of Karnataka is along the same lines as the service of the central government. Services are divided into groups which are further bifurcated into cadres. There is no confusion that a cadre is not synonymous with a group. The first term of the reference for the Ratna Prabha committee was to collect data cadre-wise. The conclusion of this court in BK Pavitra 2 that the expression cadre has no fixed meaning in service jurisprudence is contrary to the judgment of this court, which has been referred to above while answering point 2. In clear terms, Nagraj held that a unit for collection of quantifiable data is cadre and not services, as has been held in BK Pavitra. Article 16(4)(a) of the Constitution enables the state to make reservation in promotion for SC and ST, which are not adequately represented in the services of the state. Moreover, the provision for reservation in matters of promotion is with reference to classes or classes of post in the services under the state. The group consists of cadre is a fact which was taken into consideration in VK Pavitra 2. The conclusion that a collection of data on the basis of the group is valid is contrary to the decision in Nagraj and Journal, because Pavitra 1 held that it has to be in groups. That was negated. The state, last paragraph, should justify reservation in promotion with respect to the cadre to which the promotion is made, taking in account the data pertaining to a group, which would be an amalgamation of cadre in a service, would not give the correct picture of the inadequacy of representation of SC and ST in the cadre in relation to which reservation in promotion is sought to be made. Rosters are prepared cadre-wise and not group-wise. Sampling method which was adopted by the Ratnakava committee might be a statistical formula appropriate for collection of data. However, for the purpose of collection of quantifiable data to access representation of SC and ST for the purpose of providing reservation in promotion, cadre, which is the part of a group, is the unit, and the data has to be collected with respect to each cadre. Therefore, we hold that the conclusion of this court in BK Pavitra 2, approving the collection of data on the basis of groups and not cadre, is contrary to the law laid down by the court in Nagraj and Journal. It is made clear we have not expressed any opinion on the merits of any individual case, as we are only answering the common issue that were formulated. So basically, without any basis, without any intelligible differencia, you categorize service into A, B, C, D. You take up A, deprive us of our benefit of consequential seniority. C, D, we say we will give you. Thereby meaning that as I go into the A cadre, I again lose my seniority. It is totally fallacious, it is totally illegal, it is but tainted with legal malice, and it doesn't stand the scrutiny of law. Lordship will quash this government OM as violative of constitutional provision, overriding statutory provision, and it will direct that all promotion given pursuant to this OM needs to be set aside and quashed, and the correct position of law is laid down in single bench, division bench, and Supreme Court decision needs to be complied. This is my submission. And in fact, one thing I like to say, Malat, the other cases are similar. Malat, cadre-wise promotion were given all along. Suddenly, with the OM, they come down. Facts are basically same. We'll give a chart of their cadre, which cadre they went. And Lordship, on the last occasion, I made a submission. That item number was different. In the last occasion, your Lordship said that on the next date you make that. Well, what has happened? These cases, there were two issues. One was the 16 OM and the other was the 2023 OM. The 16 OM cases are item 68, 69.
No, you give a chart. You make a chart and pick words.
I'm not talking about the, I'm saying that your Lordship will segregate.
That's what I'm saying. So you have to give a chart.
Yes.
If provide a chart.
Yes.
So to expedite this segregation.
The reason is that item 68 to item 72, item 68 to item 72 is cases prior to the OM of 2023. So those are covered by IV Guhai and single judge and division bench. So these cases which have come can sum up on a separate date where I can seek for a consequential order, because there no hearing is required. Consequential order. The OM of 2023 will be a subject matter of Langthasa's case. That is item
Which
number.
items, according to you, do not require this hearing that you?
Malam?
Which items in the list?
Item number 68 to 72. They were denied promotion on the 16 OM. So clause 4. So that clause 4 is gone now. So only I can say that consequential order pursuant to clause 4. Pursuant to.
They're not agreed by the new.
No, because their selection process challenge was on that. But subsequently, they have challenged their selection, which is at other matters.
They had challenged 16 OM.
Subsequently, the 2023 OM coming in as an abundant caution, because now in the future promotions, when they go up, again, the Assam government will say that you will be covered under the 2023. So what I wanted to say that your lordship can at least, not today, on a particular date, can pass orders on 68 to 72 because it is already as it is 16 November, where the judgment is already. At least I can pray now after the division bench.
No, you want to say item 68 to 72 is covered by DB.
Yes, yes, that is the thing.
And you are not, as on date, you are not agreed by 23.
Not because my promotions, still not, though we have separately challenged it, whatever judgment comes in Langhasa's case, 363, will cover my subsequent promotion upwards. But now if your lordship disposes of in terms of Ivy Goa's case, at least they will have to give me the cadre promotion in future promotion. That I can. In fact, Pranav Rabha in item 78 and Mr. Panging 77, they have challenged the 2000, will covered by Ransasa.
Yes.
Obliged. Yeah.
You want to, are you concluding today or you'll require some time? How much time would you require?
I'll require some more time. I can start. One basic thing I would like just point out will be quite relevant. Well, this Bhagwan Patar's judgment was delivered on 6/6/2022. And it has been pointed out very clearly by either of the sides that in paragraph 7, while making the determinations, paragraph 7 of the judgment panel, in one paragraph, it has been very clearly indicated that in terms of Article 16(4)(a) and 16(4)(b), which are enabling provisions, the state is at liberty to provide for constitutionality or not to provide for it. So far as catch-up theory is concerned, when it's clear, Supreme Court has made it clear on more than one occasion that if nothing is said about the manner in which the reserved categories seniority will be determined, then it is the catch-up theory which will prevail. I have shown 2-3 judgments. I'll again show my. In order to provide consequential seniority, only a policy decision has to be taken, and it has to be made. It has to be declared in the manner by an executive order. But if it is catch-up theory, nothing is required. If nothing is there, if consequential seniority is not mentioned anywhere, no policy decision is issued, it is the catch-up theory which will prevail. My learned friend possibly will agree to that.
No, see, theoretically, one can argue that. But on facts pertaining to each case, see what happens is once you promote somebody on the basis of accelerated promotion, that person goes promoted to the higher post. Now, there is a process for selection for promotion to still higher post.
Yes.
In that case, the person will have maybe in a particular zone of consideration for being considered. On the eve of, let us say, on the eve of such consideration, certain other unreserved category candidates from the feeder gets promoted. And then the whole, what do you call the seniority list gets disturbed again. Will it not get disturbed?
No, the question is not there. Question is, which theory is being followed for the purpose of determining seniority of the reserved category candidates who are the general candidates? What is the criterion to be followed? There is the whole dispute in these cases, my lord. Whether it is catch-up theory, because if it is catch-up theory, then the general category candidates who were senior to the reserved category candidates in the feeder cadre will regain their seniority. This is how they will catch up. This is what is the meaning of catch-up theory. So far as consecutive seniority is concerned, once they are promoted, once they get accelerated promotion by virtue of their reservation,
which is why I think the division bench has held that it is the DPC who's best authorized, who's best competent to decide on the quality of reservations.
No, my lord, DPC cannot decide about the policy, whether it is catch-up theory or it is the consequent seniority. The
No,
DPC
no,
cannot do
before
it.
that, the whole purpose for bringing either of these two, according to you, is to ensure that there is sufficient representation
Yes.
of the reserved category candidates. So that now requires quantifiable data, as per Nagaraj, as per so many other judgments. Now, one aspect is whether this quantifiable data is available. Now, this quantifiable data will again, as argued by the petitioner, has to be cadre-wise. It can't be in groups. It has to be cadre-wise. Each cadre you will have to find out what is the reserve category, whether they're represented, not represented. That exercise is required to be done periodically, yearly, every promotion. That we leave it to the state. Now, question is who does it? Who is required to do it? As per division bench, it is the DPC. DPC is best suited to decide whether they are represented or not. Meaning thereby that if they are not, then people belonging to reserve category who are not within the zone of consideration may have to be included for giving due representation.
No, I'll come to that, my lord. I'm just indicating one more thing before I go to that, my lord.
No, there's a purpose why I'm saying that.
Well, I've understood, my lord. I've understood.
I've not even laid out the entire query
My lord.
which I wanted to ask you.
Yes.
You see, if it is the DPC,
My lord.
DPC is to decide the suitable merit of each candidate,
Absolutely.
reserved or unreserved, whatever the criteria, whatever the yardstick. The only question of finding out how representation is to be done, adequate representation is to be done, is to decide whether all these posts are filled up adequately or not, and if not, person who is otherwise outside the zone of consideration, reserve category, will be brought in only to be included in the zone of consideration. Perhaps that does not guarantee a promotion. What will guarantee a promotion is the merit to be decided by the DPC. Once the merit is decided, is it now open for the state to say that that person who was brought up to fill up or to meet the adequate criteria has actually been given a promotion, accelerated promotion, but will not get consequential seniority because there was no decision on merit. Because if the DPC does it, then it's a decision on merit. How can you now take away the seniority of that person who has subjected himself to the scrutiny of DPC for merit?
May I respond? My lord, who will come within the zone of consideration will depend on the position of a person in the seniority list.
Ordinarily, yes.
Now, seniority list, for preparing the seniority list, one has to see, my lord, whether it is the catch-up theory or the consequent seniority which will be followed. Because if it is consequent seniority which is followed, then the reserve category candidate who got promotion earlier to
No. Catch-up theory will come only when the senior in the feeder category subsequently gets promoted.
Yes, that is the issue, my lord. That is the issue here in this case, because the OM which is under delay.
So on the day the DPC sits, there is on the day the DPC is required to take a call. Now we are on. I am using the word DPC purposefully in view of the findings of the division bench.
My lord, yes, I was just trying to refer to the division bench, but that particular paragraph.
So, if the DPC sits, DPC will take into account the seniority list, gradation list, which is already prepared by the department.
My lord, that is what I am saying. The DPC will take into consideration the seniority list. Now, for preparing the seniority list, one has to see what is the theory to be followed, because there are two types of criterion. One is catch-up, the other one is accelerated consequential seniority.
No. That's what I'm trying to. I'll rephrase my question. From the post of superintending engineer, next higher post is assistant, additional chief engineer. Let us say. Now, in superintending engineer, there are both categories of direct and reserved, unreserved and reserved category candidates. Some of the unreserved category who were earlier in the feeder post of
Senior to them.
executive engineers
Yeah.
were juniors, but because they're required to fill up these posts, they were picked up and given
Reserve category.
reserve category.
Yes.
They were given accelerated promotion. So they became promoted higher and ordinarily would have ranked higher in the selection list. Gradation list. Subsequently, the unreserved category candidates came to be promoted.
Yeah.
Now, in whichever category you want to fill up, you decide, there has to be an assessment of merit. Once the assessment is done on merit and a person is selected, can you now take away the
My lord,
consequential seniority?
the government is never doing that, my lord.
Hmm.
The government is never doing that. Here, my petitioner's issue or contention is not that. What the petitioner is contending is that by the OM of 18/1/2023, when the government taking the liberty granted by this honorable court in Bhagwan Pata's case, issues an OM that see for category A, this is the manner in which the seniority list is prepared by taking into consideration the catch-up theory. Now they are challenging it on the ground that no, catch-up theory arguments are like this manner. Number one, catch-up theory has become a redundant theory. It has been dispensed with. It is no longer in force because of Article 16(4)(a). Now, today, for the first time, my lord.
Okay, let me further rephrase. This this theory of consequential seniority has been in place since when? Which date?
2020, 2002.
2002. I think prior to that, by which the earlier notification was done away with.
2002.
Can my learned friend now say that the catch-up principle is still there?
So, if the earlier catch-up principle was done away with,
it is his argument.
No, as per the OM. Where is that OM?
2002.
Page 46. Well, possibly my learned friend has not gone through page 46.
No, I'm sure he's gone through. He's
Well,
not somebody who will not argue without going through any document.
This is how he argues the cases, so I don't mind.
Well, Lordship will come to page 46.
Please come to page 44.
Yes, 44. I will come to page 44. This is the 12th June 1996 OM. Fixation of seniority of reserve vis-a-vis general candidates in promoted post. The Supreme Court of India, in its judgment dated 10/10/95, as reported in 1995 6 SCC 684 in Union of India versus Virpal Singh Chauhan and others, have held that while reserve candidates entitled to accelerated promotion, they will not be entitled to consequential seniority. While the rule of reservation shall be applied and the roster followed in the matter of promotion to or within a particular class or category, the candidates promoted earlier by virtue of the rule of reservation roster shall not be entitled to seniority over his senior in the feeder category, and that as and when a general candidate who was senior to him in the feeder category is promoted, such general will regain his seniority over his reserve candidate, notwithstanding that he is promoted subsequent to the reserve candidate. This
Now we'll just pause here for a moment, Mr. Mozumdar. This was the position in 96.
Yes. Hello, let us be very specific and short. 1996 is in favor of catch-up.
Yes.
2002 is in favor of consecutive seniority.
It was done away with.
Now, Lord, can you give me some time? 2016 again catch-up came. Then they have challenged. That part is clear, my lord, in Bhagwan Patar. Now, what is the judgment in Bhagwan Patar? Let us see, my lord.
03.
It is available here in this case itself.
103.
103. Yes. Now, Lordship may kindly turn to page 105.
Yes.
Page 105. Somewhat in the lower portion, my lord, Roman 9. Article 16(4)(a) and 16(4)(b) being enabling provisions. My learned friend is arguing that by virtue of Article 16(4)(a) and 16(4)(b), catch-up theory has gone. It is the consequent seniority. That is not correct, my lord. Repeatedly he is submitting like this.
No, that's it.
And Lord may kindly say, I am reading it again. 16(4).
We agree with that. It is an enabling provision. You are at liberty to provide or not with provide. All this
Yes.
I've understood.
Now,
What we want to know is with effect from 2002,
my lord,
you have provided the consequential seniority. You have continued to provide them with consequential seniority.
2016 it was taken away, my lord.
No,
That is why
16
this challenge, my lord, why this writ petition was filed.
No, 16, if you come to page 103,
My lord.
at clause Roman 10,
Yes.
there is a finding by the single judge that it
Yes.
is incompatible.
Well, that's what I'm saying. That is what I'm pointing out. Now further, we have to go ahead.
Huh.
Now page 105, Lordship, may kindly see. What has been, let me read, my lord.
Right.
16.4a and 16.4b being enabling provisions, the state is at liberty to implement its policy of giving reservation promotion with consequential seniority, comma, at liberty to provide for reservation promotion without consequential seniority, or at liberty not to provide any reservation promotion at all. So the three things are there. You can provide for reservation promotion, you can provide also for reservation promotion with consequential seniority, and you can provide for reservation promotion without consequential seniority. It is clear from this paragraph. Now, Lordship may come to the OM. It is available at page.
So then you read the para 8.
My lord.
So it was interfered to that extent.
My lord, Lordship may kindly come to page 107.
107.
Yeah.
Yes. That is the 23.
That is the OM under challenge in the writ petition. My very first paragraph. The Honorable Guwahati High Court in its judgment and order dated 6/6/2022 in WPC number so and so, that is Bhagwan Patramai, which I have just now read, and WPC number so, it is a common judgment in both the cases, my lord. At para 7(9), Roman 9 of order has observed that this whole paragraph. Now this liberty, taking liberty, my lord, the government has passed this order. Now it says the government of Assam, after careful examination of the Honorable Guwahati High Court judgment dated so and so in WPC and so and so Equality Forum and this Bhagwan Patar, has reviewed the existing procedure of effecting reservation promotion with consequent seniority for reserved categories, and accordingly lays down the following guidelines to be followed while considering promotion in any establishment. Now we have come up with this OM taking liberty granted by Bhagwan Patar. Now, thereafter, my lord, they have filed this writ petition challenging this, primarily taking the cue from the judgment, the paragraph which Lordship has just now referred. In between, my lord, this is what I wanted to point out. In between, this was put to challenge before the division bench. Lordship has seen in the my lord, morning, my learned has pointed out that the IV Guhai is the judgment passed in writ appeal, where this was under challenge. Now, what has been observed in IV Guha will be of much importance because they have filed the writ petition at a time when this Bhagwan Patar single bench judgment was there. Subsequently, when division bench judgment came, as your lordship has indicated in the morning hours, my lord, that we have to now go by the division bench order. Now, what is there in division bench order that your lordship will kindly see at page paragraph 45 of that judgment?
Yes.
Paragraph 45, if your lordship has got my lord, may I read?
Yes.
A reading of clause 4, this is clause 4 of the 2016 OM which they challenged. A reading of clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of the reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category candidates who on merit are also entitled to promotion, his or her cases are to be considered for promotion on merit only if such candidates has not given seniority by way of any accelerated promotion. So accelerated promotion, it would mean, well, this is further clarified. It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequent seniority as provided in OM of 12/3/2002. Lordship will see kindly. But on the other hand, if the posts earmarked for the reserve category candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list there remains some further reserve category candidates they can compete for promotion against the unreserved post. Lordship will kindly see that they are not being debarred. They will be considered for unreserved post, but in such an event, they would not be entitled to the benefits under consequent seniority. Very clear. They would not be entitled to the benefits under the consequent seniority. And on the other hand, if on the basis of their seniority otherwise, that is, without taking note of the consequent seniority, they are within the zone of consideration, such candidates can be considered as for promotion. This is purely, my lord, an approval of 2016 OM, which they put to challenge in the single bench judgment. Now, in view of this, they have not amended the writ petition. They have relied only on the findings of the almost single judge in Bhagwan Patar. Bhagwan Patar has been modified by the division bench judgment. This finding has come up now. There is no amendment to the writ petition. If my learned friend says, no, I will not accept this, then he has to challenge it. If he accepts this, then it is the revival of the OM 2016. Absolutely same. My lordship will kindly say what is there in OM 2016. My learned friend is annexed. This is available at page 63, my lord.
Yes.
63, it starts, my lord. Lordship will kindly turn to page 65, the relevant part, which they put to challenge in the Bhagwan Padar's case, my lord. Page 65, Lordship. The second paragraph.
Yes.
If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are categories of candidates of reserve category who on merit is entitled to promotion, his or her cases shall be considered for promotion on merit if such candidate has not gained the seniority by OF accelerated promotion earlier. This is what they put to challenge before the Honorable Single Judge in Bhagwan Padar's case. Now, in relation to this particular paragraph, the paragraph Roman 7-9, which I have read, this Honorable Court has said that the government is at liberty. Now, taking that liberty when this OM is passed.
No. Now, this how this para 4 has been, according to you,
my lord,
has been answered by the division bench in para 45.
Para 45, Lord, kindly. Para 45 towards the end, my lord, the last sentence is very clear. Last sentence, starting from it would mean, Lordship has got. In fact, there are two sentences. Second sentence, I am from the fifth line from top. It would mean, Lordship has got, my lord.
Yes.
It would mean that if a reserve category candidate is seeking for a promotion against
any
post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to benefits of consequent seniority as provided in the office memorandum of 12/2002. The benefit of 2002 is restricted to that only. But on the other hand, if the posts earmarked for reserve category candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list, there remains some further reserve category candidates, they can compete for promotion against the unreserved posts, but in such an event, they would not be entitled to the benefits under the consequent seniority. This is what is there in OM of 2016, which I have read. And on the other hand, if on the basis of their seniority, otherwise, that is without taking note of consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. Now, in view of this, my lord.
But is it not in principle
this is
going against the judgment of the apex court?
No, my lord. Apex court judgment in
the availability of unreserved posts for a reserve category to compete has been upheld.
Yes.
Long back.
Even by this, it is upheld. But question is, what will be your position qua your seniority position? Your right to be considered will depend on your position in the seniority list. Lordship will kindly see there is one difference. A person down below the list cannot be considered for promotion because he has to come within the zone of consideration. In order to come within the zone of consideration, if you have got accelerated promotion, your accelerated seniority cannot be considered for being considered for a post which is not reserved.
Or is it a case
My
that uh, it only means
My lord.
that in the event the authority who's deciding whether it is a DPC or the committee or whatever
My lord.
authority
My lord.
repose with this responsibility
My lord.
finds that there are vacant posts available
My lord.
and some reserve category candidates are required to be considered, they are picked up or they are within or outside the zone of consideration, irrespective of that, they will be considered for filling up. In which case, they will be entitled to consequential seniority.
No, my lord, I'll put it the other way around.
Hmm.
Whether he will come within the zone of consideration or not, supposing considering the number of posts, 4 persons are to be considered. The person whose position is at serial number 4, if this position he has acquired because of application of the consequential seniority, that seniority will not be considered if he is considered for a promotion to a post which is otherwise open.
Can it not be interpreted in the other way around, that there are these 4 persons
My lord.
and number 4 is a reserve category?
My lord.
And these among these 4 persons, among the let us say, that means there are 2 posts. Let us say
My lord.
2 posts to
My
be
lord.
filled up.
Yeah.
One post is reserved, one is open.
Yeah.
And number 3 and 4, let us say, are reserve category.
Yeah.
Now, 3 will be considered for that reserve category post because it is vacant.
And 3 is reserved, my lord.
No. Let us say there are 4 persons.
My lord.
There are 2 vacancies.
Yeah.
One reserve, one non-reserve. So, in the seniority list, person at serial number 3 and 4, they are reserve category.
Right.
So, for the person at serial 1 and 2, they can't compete for the reserve category. There are 4 persons, 1 and 2 are unreserved, 3 and 4 are reserved.
Yeah.
There are 2 vacancies, one reserved, one unreserved.
Yeah.
So these at the gradation list of 1 and 2, these persons, they obviously can't compete for the reserve category. Cannot be
They are
selected.
general.
General category, unreserved.
Yeah.
So they'll have
They
to
can
compete for the
one post.
only one post. 3 and 4, out of that, let us say seniority 3 is there, he's picked up and for selection or promotion to the post of the reserve category, reserve post. 1 is filled up. Now that leaves you 3, that is serial 1, 2 and 4. 4 is a reserve category.
Yeah.
Can it not be interpreted to mean that even this 4 now is available to compete for the unreserved category? And if he's selected,
Yes.
if he's selected
On merit,
he
can be considered. Yes.
But can you take away his right for competition only on the basis that he had he is otherwise in the zone of consideration?
And that is why I am saying this is the interpretation required by your lordship, madam.
How can that interpretation be given by the single bench? This is whatever it is, whatever judgment, whatever finding is there in 45 is binding.
Well, if I may clarify with the lordship leave, very interesting.
Well, what I'm
Well,
saying
this
is,
was an argument.
the 2016 OM is this.
The proposition which you are trying to present before the court will require re-evaluation of the gradation list at every promotion by referring back to the original gradation.
This is only for the purpose of giving effect to the principle of catch-up theory.
That's right. So every promotion, every
promotion will be
every promotion, there will be some number of reserve category posts.
Yes.
There will be some candidates for reserve category posts.
Yes.
So to decide whether they will get the benefit of seniority or not, you are now going back to the original, the gradation list, feeder category.
My lord, that is what I'm saying.
To redecide.
My lord, whether they can do it or not will depend on the question, what is the principle in place?
No, whatever your principle in place is with effect from 2002.
No, it is not there. That's what I'm saying. In 2006, my lord,
principle,
kindly bear with me. The 2002 consequential seniority was taken away in 2016 by the OM of 2016. And that is why they challenge. What was the challenge, my lord, in Bhagwan Patar?
All right, let us say
My lord.
2000 single judges allowed that challenge. Single judges held that it is
Liberty is there.
It is not in superstition.
Single
It's not
judges
in
said,
superstition.
you are my lord, single judges on the one hand said 2002 constitutionality will prevail, and on the other it has said that you are at liberty. Since it is a matter of policy, you can take your own policy. Now, by the present OM, impugned OM, a policy has been taken that we will go with the catch-up theory. Now, can they challenge the saying that
Nobody is questioning the state's power to apply or not to apply.
That is why we are
Question
saying
is
we
that
are
your single judge has held
my lord.
that 2002 the policy was there.
Yes.
Policy was not there. Let us say was not there. You have tried to bring it by way of 16, which cannot be done because 2002 has never been superseded. But the government has the power.
Yes.
Now, therefore, you have brought in 23.
Yes.
Now the question is, by bringing this power, are you taking away certain enforceable rights?
No, my lord.
That is the question.
No, my lord, will kindly bear with me. When the single judge has very clearly said that, see, the single judge has made the observation not because the court wanted to make the observation.
Single judge did not go into this aspect of what will be the rights, if at all, enforceable for the petitioners if the right of the state is to be given effect to, assuming by 16 or by 23.
The single judge was dealing with the question as to whether the government has a right to take any of these two policies.
No quarrel about that. You absolutely have a right. Have a right. But the question is, once you decide to put in that, give the benefit with effect from 2002, some persons have acquired certain rights.
2002 policy that was taken is not for all time to come.
No, quite right.
Yes.
You can certainly change it.
Yes.
But can you do it retrospectively? It has the retrospective effect.
No, it doesn't have.
It has.
It doesn't have, man.
You are taking away the seniority of a person who he has attained from 2002.
Absolutely. My lord,
you may like to do it.
Right now, my lord,
You may like to do it from a prospective date. That this policy will not be applicable from, say, 20, 27, 28, whatever, in these posts.
I'm
That's
right.
a different issue.
I'm presently on the validity of the OM, which says that consequent seniority will be there. Whether retrospective can be given or not, that's a second issue.
We are only trying to understand in view of this, so many judgments being pressed. The one thing is certain that yes, 16(4)(a) is an enabling provision.
Yeah.
State has the power to give or not to give. Division bench has also not held that the view of the single judge that 16 does not supersede 2002 is incorrect. That's not the view of the division bench.
Yeah.
But fact remains that the right of the state to bring in an OM or not to give the effect or not to give the effect has been crystallized, identified.
But the argument now they have developed that it is being implemented retrospectively. That is not the case before Lordship.
No, it's not their argument. It is my understanding.
Always.
It's not their understanding. Not their argument.
We are bound to reply to your queries. But so far as writ petition is concerned, that is not their case. Writ petition is premised on this simple thing that Honorable Single Judge has said that 2002 prevails, but the writ petition has not taken into consideration the liberty granted in paragraph 7 and the validity of the OM of 2023 is not challenged on the ground that even in view of the liberty, it cannot be done. Am I clear, man? The writ petition is based on the simple thing that, see, Honorable Single Judge has said so, that 2002 will prevail. But the liberty which has been granted, they are trying to challenge this liberty, though not in very clear terms.
That liberty.
They are challenging.
Liberty, of course, the state has. If we have to hold that pursuant to Nagaraj, it is an enabling provision, 16.
Yes,
liberty is there.
This single judge's judgment also makes an observation.
The only question, perhaps, which we like to hear from you is, notwithstanding this 2002, there is no enforceable right insofar as the petitioners are concerned. Therefore, we are within the state is within its rights to bring out 23.
Yes.
OM dated 23.
I'll just point out one thing. Madam.
But you're right, ultimately it is para 45.
Yes, para 45, what I'm trying to indicate today is
Ordinarily, either of the parties should have approached for a clarificatory order.
Yes.
Here I may, with your lordship's leave, just clarify this point. This point in the first, because this is the third day I argue. On the first day, I made it very clear that 45, we don't want consequential seniority when we go up on merit in the higher post. So we can ignore that part because the learned judge added with the rider that if I'm entitled otherwise under the rules, you cannot take it retrospective. And retrospectively was one of the arguments. In fact, rightly said one judgment I missed out. There's a very recent judgment of the learned single judge on this point that the OM of 2023 is always prospective. Retrospective, you cannot take away. This.
But that is not a ground in the today you are arguing.
No,
when the court is
this was
pointing
an
out.
argument I made on the first occasion when I said that
Let me
when I move up the cadre, you take away
earlier also when I started, immediately after I started, my learned friend has
I'm not fighting with my
I have again started, he's now standing up.
Blocking you.
You
I'm
let
just
me
clarifying.
I did not interrupt.
We as lawyers can always clarify any point.
I
But
did not
lawyers
prevent
should
him.
not
Let
think
me,
that it's an
I'm trying to
adversarial
frame a argument.
Well,
No. Mr. Mazumdar is trying to frame his arguments. Did you listen to it? You will have your right of reply.
From this Bhagwan Patha judgment, one line I would like to point out. Paragraph 4, Lordship may kindly see.
Para 4.
Para 4.
Yes.
The para 4, man.
Yes.
The ratio of the aforesaid judgments, more particularly M. Nagaraj, Journal Singh 1, B.K. Pavitra 2, Journal Singh 2, can be summarized as follows. 1, I am ignoring. 2, also I am ignoring. My Lordship may come straight to Roman 4. The catch-up rule and consecutive seniority are judicially evolved concepts.
Sorry, we are unable to find out which
paragraph 4, possibly the paragraphs are not telling with the judgment I am holding, a copy of the judgment I am holding.
Paragraph is a part of the writ petition.
Oh, yes. This, yeah. My lord, yes. Page 93.
93. Yes.
Page 93, paragraph 4, Roman 1, then Lordship kindly turn to page 94.
Yes.
Roman 4 in the middle.
Yes.
The catch-up rule and consecutive seniority are judicially evolved concepts based on service jurisprudence, do not violate the basic features of equality of the Constitution. Both are judicially evolved principles. My learned friend at one point of time argued when your lordship put a specific query that where is the reference of consecutive seniority in this amended provision of 5A. My learned friend has given an immediate reply that it is implicit in it. It is not there. 5A was inserted in the Act after the RK Sabharwama judgment, which said that there will be post-based roster or not vacancy-based. Meaning thereby, my learned friend doesn't clarify. He argues one point here, then jumps to another. So that is very difficult. Even I have to reply, my lord. He makes a point, I have to reply. I can't catch the point because
he argues in such a manner that you cannot reply.
Yes.
That's his purpose.
Yes.
So you can't blame him for that.
We have to assist the court so that court can pass a judgment. If I keep on arguing like this, your lordship will not be able to catch, my lord, what is my argument, what is my reply. My lord, my submission here is RK Sabharwama's judgment is on the question as to whether post-based roster will be there or vacancy-based. Meaning thereby, if 10 every time vacancies arise, you cannot effect reservation, saying that no 5% of supposing 10 vacancies have arisen today. If the vacancy for the particular category is 5%, out of that there will be only 2. Next time again 10 vacancies arise, again you will say 2, that we will cross your limit. That is why the Honorable Supreme Court says no. It was a case of railway, my lord. There, this was the argument. They said no. On top of that, my lord, the Honorable Supreme Court in that case said that if a reserve category person gets a promotion through the general category, because by competing with the general category persons, if he gets a promotion, this appointment will not be taken into consideration for the purpose of seeing whether the percentage earmarked for a particular reserve category is achieved or not. These are the two things. Now, this has got no relation with the consecutivity or catch-up theory, but my learned friend repeatedly argues that it is the post-based roster, so catch-up theory. See, where is the relation? There is absolutely no relation, my lord. Let my learned friend show from any Supreme Court judgment that there is a correlation between the catch-up theory or the consecutivity with the post-based roster. Why learned friend is reading out one section 5A to confuse the court or to confuse me? Why? There should be some reason. You try to relate this to any of the points you are arguing, but simply saying, my lord, it is a post-based roster, it is post-based roster, so catch-up theory. And Lordship has put a specific question, where do I find the catch-up theory in section 5A? My learned friends, it is implicit. How? It may be implicit. It may be an argument, but kindly clarify so that I can reply. There he goes to some other fact. This is not the way, my lord, a person will argue his petition. I have to give a reply to the argument, my lord.
Okay.
So, my lord, my first submission here is the writ petition now contentions which my learned have raised are beyond the pleadings in the writ petition. The question which your lordship is putting now is beyond the writ petition. My learned has not framed the writ petition in that manner.
The retrospectivity.
Yes, absolutely not there, my lord. The whole writ petition, I have seen the writ petition, my lord. In the writ petition, they have relied on a particular paragraph of Bhagwan Patar, but subsequently when that paragraph was modified in paragraph 45 of the writ appeal, my lord, in IV Goai, there is no change in the contentions raised. What will be your reply to paragraph 45? Because for paragraph 45, my lord, word by word is an approval of 2016 OM paragraph 4. Word by word, I pointed out just now, my lord.
Yes.
And thereafter, we have to see the observations made in the writ appeal by the division bench of this honorable court with the liberty granted by the honorable single judge to test the constitutional validity of the impugned OM, my lord.
Yes.
If he raises a question of retrospectivity in relation to certain facts of the case, in relation to some judicial list, my lord, then we'll have to reply by filing an affidavit. That is not a contention in the writ petition. Lordship has made a query, I am bound to reply. That's another thing, my lord. But so far as the writ petition is concerned, Lordship will see this point was never raised. And we have not been given the opportunity to reply to that.
Yes.
Now, Lordship, the argument is that catch-up theory has become redundant in view of Article. Today also my learned friend has submitted that in view of amended provision of Article 16 by the two amendments 77 and 85th, catch-up theory is not there. If my learned friend says, no, I'm not saying so, then I'll not argue. But if he says that by virtue of these two amendments, 77 and 85th, catch-up theory rule is not there, catch-up theory principle is not there, then I have to point out all those judgments which says that no.
That's his argument. That
Yes,
was never there.
Then I have to show. Yes.
I'll give my reply.
Yes, yes, of course.
In fact,
We'll proceed in some other date.
Can it be on Monday?
Not Monday.
Monday?
I had a talk with my friend, and he says that on 8th, Mr. Chaudhary will also give his reply.
No,
Because
8th we
9th I
can't
have
have it because 8th there are already a lot of parted matters leaks.
9th I will be on leave. Can it be on 6th?
Fifth is a Monday. Fifth is a Monday. Oh.
This will cause discount.
Can we have it on 13th or 15th?
No.
If we can have it on 20,
It's better, my lord. Even I'm also.
very few
I-
matters are there. We
my
can
lord, I'm
actually
also
conclude
comfortable.
the
But
hearing
yes,
on 20,
let it
20.
go 20.
Matters have been heard at some length. Hearing remain inconclusive. List for further hearing on 2002, 2024. Mr. D. Das, assisted by Mr. Uh, your name, please? Appears for the writ petitioner in WPC 5. What is the number?
363
363
and 663
and
665 of
665. Mr. T. Mazumdar, learned additional AG, assisted by Ms. So appears for the respondent state. Then Ms. M. Das for PWD. Mr. Gautam for the respondents, private respondent. List again on 20. Stapler.
Confusion.
My learned print says he subsequently filed one affidavit. I have not seen that.
No, not everything. But I have made my submission regarding retrospectivity because I have brought in
My
an
lord,
argument on.
in fact, my lord, possibly in this 363 and 366 also. Government activity too.
আছে এইবাৰতো পঢ়ি দুখনতে
নাই
এতিয়া কৈছে যে ইন ভিউ অফ দি নতুন OM আমি তোমালোকৰ নকৰো সেইটোৱে বেলেগ নাই
My lord, if necessary, we'll file an affidavit in the lordship. I'm just making it.
No, factually, there is no dispute.
And that's what I mean.
So even if you file in the middle of the hearing, if you insist that it has to be filed, you can look into it. There's no problem.
because only issue
Because
is that
subsequently-
we brought in the
So
rules.
now the issues, because this was the issue raised on the first day, is the interpretation of para 45.
Yes.
So depending on how it is interpreted, the
Yes.
further questions, if required, will have to be answered.
Because Lordship, if the division bench has said something contrary to the division single bench, the Supreme Court, we can be.
It is for you to say that. You have not said that so far.
That on the first day when your Lordship asked the
You
question,
have interpreted saying that division bench has upheld your arguments.
No, Mala.
So
I say that.
इसको अभी करिए अभी उसको स्टेबल कर देना मिसप्लेस
Difficulty is language of OM 2016, which is the challenge in the single bench, is same in paragraph 45 of the division bench judgment.
All right.
Lordship will
Their
consider.
case.
List on 20.
20th. Deep.
Wow.
Time being.
May it please the Lordship. Lordship, this matter pertains to non-payment of some arrears salary. Here my
We were
client-
thinking, why not dispose it off instead of waiting for the.
Lordship, once this prayer is there, I want to make a submission on the payment of interest part. I'm paying for interest. My prayer is for.
You pray, you make whatever submissions are there. You
sir.
you will we'll permit you. Have you filed any representations?
Admitted portion that arrear is there. The last signature, Your Lordship. Page 48. Some other day, Lordship will kindly hear this matter and I'm praying for some interest on this.
Okay. Then we defer it. Get your instructions. List after 2 weeks.
Very well.
As prayed for by the learned standing council for instruction.
The date, if all possible.
Date you take it from the court master.
Obliged.
Yes.
Very obliged.
Oh. Hey, other matters will defer it. 81 क्या है? Admission.
Not right.
Yes, yes.
May please, Your Lordship, I pray that Your Lordship may kindly adjourn this matter today.
Adjourn.
Well,
The
the
request
date
of learned counsel for the petitioner.
Date may fix, my lord. 9 minutes.
Why? Some interim order is there.
No, my lord. Actually, from 11 to 15, I may not be here.
We'll defer it after 15. In the first week of March? First week of March? Yes. Mr. S.K. Medi for?
I'm for University, Tezpur University.
Tezpur University.
Lordship, I am for
Mr. Talukdar for
Director
accountancy.
General of Audit, Lordship.
It is that amount
yes,
which was to be released. What has happened with that?
Lordship, on last occasion, the Lordship sir directed to file my one affidavit, Lordship, and accordingly I filed, Lordship.
You have filed it.
Yeah, filed. So that is on record, my Lord.
Mr. Talukdar submits that an affidavit has also been filed, which is on record. At least after 3 weeks. Yes.
6th of March, my lord.
Huh?
6th of March.
6th of March. Yes, 6th of March.
May I please, Your Lordship, this matter hearing has already been concluded by you.
Huh?
My lord already heard the matter.
Ah.
Today matter was fixed for order.
Order, ma'am.
Oh. It is that
FCI matter.
FCI matter.
FCI.
Loss.
Loss.
Shed in charge.
Loss, said in charge.
Loss.
Yes.
Let us keep it on 12. Sorry, on 13. 13th.
Oblige.
इसको नोट कीजिए तो 13 में for delivery of or order. नहीं तो hearing पे ही रखिए but you take it 13 को नोट करके ये रख दीजिए. Yes. Yes. Huh? 59. Pass over.
Lordship, my senior had to leave. Kindly pass over to me.
Passed over. Any stay order?
No, no.
All right, these hearing matters will come up in part 2 lists in the month of February. All these hearing matters
Lordship, item number 63 regarding pensionary benefit, Lordship.
will come up in part 2. Part 2
Part
matters.
2 may not be reached, Lordship. I have in part 2.
It will come up in the list.
Lordship.
So that you make a mention, depending on the urgency, we'll take it up. The difficulty is if it doesn't reach, then we have to fix a date. We do not know on that date whether it will be taken up or not. If we put it in the regular hearing list, we can take it up every day.
Lordship, I have getting.
Hmm?
Both sides are ready. Small point, Lordship, only.
Both sides are ready. It is 4:15 now. Yes.
Up to their losses.
Then passed over.
Other
My lord, come part 2 list, he'll make mention, madam.
losses
I'm ready.
cannot be
Part
reached.
two,
Losses by facing more. They are paying pension 6th pay commission, but I am entitled 7th pay commission, and one period has also been deducted.
Let it be listed in the regular hearing list. We'll take it up. You make a mention
Yes, ma'am.
on that date.
Yes, ma'am.
Matter be listed in the regular hearing list. All these matters. Hearing leftover जो भी है to be listed in the regular hearing list.
Well, only for part 1 hearing this, my lord?
No, regular. Part 2.
All these.
You are entitled to make a mention and tell us which matters.
Sometimes my item number 16 the pension matter, my lord.
Item 60.
60, my lord, and 61. There is a direction to produce the record. Record is available with the. So any date, my lord, in the month of February, my lord.
Who is to produce the record?
Parashar, my lord.
Who is to produce the record?
Respondent, my lord.
Who is the respondent? You have the records.
Yes, my lord. His name not with us.
Huh?
Parashar. Record ka anasam question.
You have the records.
I have no knowledge.
You have no knowledge. We'll get the records even if it is listed in the part 2 hearing list.
My lord, can leave on part 1, my lord. Can it be on this matter only? I'm praying.
The part 1 will end up like this.
That is the problem.
The part 1 matters end up like this. It gets deferred to another date. Therefore, we are putting it in part 2 list so that we can continue the hearing even on a miscellaneous day. All right? Yes. All? सारे पार्ट 2 में चले जाएगा ना अभी क्या बता रहे हाँ ऑल दिस हियरिंग मैटर्स विल बी इन पार्ट 2 पार्ट 2 लिस्ट हो गया